By victim mentioned item number 3, Your Lordship.
Hmm.
In this case, Your Lordship, an affidavit has been filed, Your Lordship, to the Your Lordship may be allowed to bring the record.
Your Lordship, my lords, item number 19, my lords. Finally, this case was leading by the Mr. G.S. Sarkar. Now his few months ago is dead. And filing the my lord, the G.S. Sarkar. So I bring the file, my lord, today, my lord, and I will bring the file today. So my humble submission for that day may be mentioned.
Read the file till it reaches.
May please.
Who come up with this type of argument?
I'm praying for listing on motion matter, Lordship. It will come up on 28, Lordship. Okay. May please, Lordship. In connection with item number 13, Lordship, yesterday I have filed an affidavit, Lordship. That may kindly be allowed to file it, Lordship.
May I please, Lordship? Item number 18, Lordship. 18, 1 8, Lordship. Here, Mr. Prakash is supposed to appear, my lord. He is not feeling well, so last 2 days he could not come.
Huh?
Mr. Prakash is there in the case, my lord. And he is since not feeling well and not appearing. So I beg that the matter be possible, my lord.
No.
And one, here, my lord, yesterday we have filed and the rejoinder file also. The rejoinder also we have filed yesterday late. That also may come in the record, Lordship.
Bring on record.
But he is not unable to appear. So today, in that case,
Don't worry. If he is not able to appear and
I-
if there is no case, I'll dismiss it.
I seek indulgence of Lordship for along unlisted matter, eviction matter.
Huh?
Without serving a notice, James, your authority says, come with it before listed.
Yeah.
It is the last item. It is the last.
Oh. One item. Mr. Biswas, your matter.
Lordship, just one, I had one prayer. In item number 12, we filed an additional affidavit in the morning that may be brought on record. Deeply obliged.
You want to withdraw?
settled.
The SC Biswas, the learned counsel appearing on behalf of the petitioner, submits that as the matter has been settled, the petitioner would not like to further proceed with the instant proceedings. Accordingly, the instant petition stands closed on withdrawal. Personal appearance. Yes, where is the affidavit?
Affidavit is. Yes, Lordship, it's.
You have got a copy?
Tonight. But Lordship, what I have been told, Lordship, that 1 katha 17 lasses of land was of the petitioner, Lordship. It was bounded by the FCI, Lordship. They have taken 1 katha 17 lasses, but only 7 lasses was acquired at that time. So, in addition to that, it was in position of FCI 1 katha 10 lasses. Of that 7 lasses which was acquired earlier by way of a LA case number 12, that 7 lasses, that money is with us, Lordship. We can give it at any time. of the 7 lesser, but that 1 katha 10 lesser,
Who is going to pay 7 lessers money? You have kept it with you.
yes, Lordship. It
Why?
is with us.
Why?
It is with us, Lordship, at any time.
No, this was done long time back.
Lordship.
Who is going to
And,
pay the
uh,
fine?
It is with regard to that allegation number 12. But
Who is
even that,
going to
Lordship,
pay?
it is with us, we can, at any time, Lordship, we can
You have to pay with interest,
Obviously, Lordship.
and the interest has to be paid by this officer from her pocket.
That I
from her
leave,
salary.
that I leave to your Lordships, but
No, no.
regarding that other
Because
1
this
katha
is-
10 lesser.
This is being done. So you pay and then you recover it from the officer.
Regarding that other 1 katha 10 lessers, Lordship, that 1 katha 10 lesser, it is under the occupation of the FCI, but we have told them that you, by direct purchase, Lordship, they can negotiate it with the petitioner, but that was not yet
You
been done.
demarcate that land, give it to the petition.
And regarding
If
that,
the
Lordship,
walls
we have,
are there, demolish it.
Lordship, may I submit, Lordship? Only one sentence, Lordship. That we are going to, acquisition proceeding, just we are going to initiate the acquisition proceeding regarding that, Lordship.
Why?
1 katha 10 lessers. Lordship.
Why?
That's because it is within the, otherwise, Lordship.
Why
they
is
have-
the state government getting involved in respect to
Lord-
a dispute between him and him? Have they made a request? No, have
But
they
that
made
is
a
the
request?
fact, Lordship.
No, Mr. Sharma,
Lordship.
have they made a request to you?
No.
Then why are you doing it?
No, yes, Lordship.
Is it conceived of that the state government takes the role out there?
Amar repeating with one word. Yes, Lord. তখন আইছে।
And what is this type of error? This notification which have been issued,
Lordship, may I pray, Lordship?
what is this Chatak business? This is in which place? Kamrup.
Lordship, yes, Lordship, it's Amingaon, Lordship.
Amingaon, where is the concept of Chatak comes?
It's in the Sinsal, Lordship.
Then this acquisition notification is absolutely wrong. Where is the award passed?
Lordship, may I pray, Lordship, after some time, as because Mr. D. Nath, Lordship, he is involved in this case and he is in a division bench matter, Lordship, it's fixed today only. After some time, Lordship, he will be coming.
After some time, we'll take the other respect. Yes, who is the officer? I've asked to be personally present.
Yes, Lordship.
Good morning, Your Lordship. I am DC Kamrup here.
Now, I asked you, there was a direction for filing the affidavit. Why the affidavit was not filed in spite of an order being passed by this court? Do you take these orders directing you to file an affidavit so lightly?
Not at all, Your Lordship. We had filed the affidavit on 18 March as well and on 24th April as well.
No. You did not file any affidavit.
Our counsel couldn't present it to the Honorable Court.
Who is the counsel to whom you have given? Who is the counsel to whom you have given? We'll ask the bar counsel to initiate action against him. Who is the counsel to whom you have given?
To our government advocate, Pavitra Kumar Medhi.
Huh? Who is the government advocate? The officer says that it was given to you.
I am a panel advocate. I have submitted the entire documents to my senior advocates.
Who?
BJ Talukdar, Your Lordship.
So we initiate the proceedings against Mr. BJ Talukdar? Because this is an absolute, for that, why his senior advocate, why his life should not be taken into account. Ask Mr. BJ Talukdar to be present. Because if it was given by you to him and he has not filed it, which is detrimental to the interest of the state, then obviously something has to be done. We can't leave it so easily.
Lordship, BJ Talukdar is not available.
No, no,
today,
no.
Lordship.
Where is he?
Some,
And we'll initiate proceedings. I'll issue contempt notice against him in view of that. Madam, you have filed an affidavit stating that you have given it to the council?
Yes, Your Honor.
Give me a copy of that affidavit. We initiate contempt proceedings against him. Let him explain by way of an affidavit. Can't take these things so lightly.
File kora nahi, file hua nahi. It's not yet filed, Lordship, they are going to file it.
typically given.
That I have narrated just now before your lordship.
Where is the explanation that it was given to the council?
That most probably.
Because my order was very clear. The non-filing of the affidavit by the Deputy Commissioner cum Collector Kamrup Amingao is on the face of it an infraction to the various directions passed by this court, to which this court takes judicial notice. What consequential order therefore is required to be passed, this court finds it relevant to first hear the District Commissioner cum Collector in person. Accordingly, this court fixes the matter again on so-and-so, on which the District Commissioner shall file an affidavit as to why, in spite of specific directions to file an affidavit, the District Commissioner Collector has not filed the affidavit, and in addition to that shall also clarify the stand as sought for in the order dated so-and-so.
Regarding
So
that,
this affidavit does not say anything.
lordship.
So in spite of this order, it has not been done. So again, there is a violation by the District Commissioner. You must have given the order to her.
Lordship, I think that is why I am praying, lordship, after some time, lordship, let him come.
No,
and
there is no sometime. If he is not in present out there, let him be there in the division bench. I can't help it. Yes, madam. Why haven't you explained that aspect by way of an affidavit when I have asked you to do so?
Your Honor, we filed the affidavit. We've also
No,
submitted.
you have
it
not
today.
stated in your affidavit why you did not file the affidavit. You are just saying verbally. Verbally would not do. You have to give reasons to whom it is being given.
Your Honor, if you give us the opportunity, if you could file an
We
affidavit
have
today,
already given you the opportunity.
no, stating these facts that we had prior to this date as well, we had already
No,
filed.
first and foremost, the opportunity has been duly given to you, and thereby asking you to file the affidavit. You have not filed the affidavit in that manner. Secondly, why is the district administration holding on to that amount of 7 letters? For what good reason?
We haven't
Is it
received
the case of the district administration taking this court for a ride? On one hand, whenever we ask you, I've narrated the entire aspect of the matter in my earlier order. Whenever I asked you about this thing, you categorically say that one katha 7 letters, 7 or 17 letters of land have been already, is not a part of that, which has been acquired. Thereafter, they file an affidavit stating therein that no, 7 chataks of land was taken. So under such circumstances, isn't your stand which was there, therefore you were asked to clarify why this has happened? I've duly
Your Honor,
taken
we've not received the petitioner's application for claiming the value of compensation for that 7 lesser land.
No, it is not a case of petitioner's affair. Here is a case where you have taken the land of the petitioner and given it to him, FCI, that too without acquiring that portion of the land. It is under distress the petitioner had to approach this court. When we ask you, you come up with a stand that no, we have not carried out this acquisition, and we have asked the FCI to make an outright purchase. FCI comes up, no, this is the part of the acquisition, the second acquisition, which you don't reflect. Therefore, you were asked to explain. Now you are coming out with the fact that 7 letters of land or 7 chataks of land have been taken, for which you have kept this 64,000. And the payment of money was made when? When did you pay the money?
It is in the
This is of LA case number 3 of 2012.
Well,
So must have been
12.
in the year 2012. The payment was made. So under such, in view of section 6 applicable, then the payment has 6.3. The payment has to be made by the requiring authority. So the payment was duly made and 12 years have gone down the lane, but you have not made the payment. Who is going to pay the interest? That too at the rate of 15%. Is the state exchequer so filled up with coffers that the state can do it like this? Or should we not implore the possibility of directing the state to pay the interest at the rate of 15% on that said amount and then recover it from the erring officials, including the period when you are in charge as the DC? Somebody's land. And now you have the audacity out here as a government advocate makes a submission to the effect that we are going to acquire the land. Is the acquisition being made at the behest of somebody private, FCI, to be done in this manner? Has the FCI ever requested you? If the FCI have not requested you, can you acquire on behalf of the FCI? Is it heard of? Tomorrow, you are only acting as an agent of the FCI, of the government, for acquiring the land for the FCI. Tomorrow, the FCI will say, who has asked you to acquire? Then who is going to pay the money if the FCI doesn't pay you? FCI have never requested. We'll take up the matter again at 2. Be present through video conference.
Noted, Your Honor.
Taking into account your government advocate is not present.
We kindly also be served to us. Affidavit that has been filed by
We are
What?
going to.
They have not yet filed. They can
Lordship.
ready. Okay. Lahok. Again, Lahok. We'll take it up at 2 again. You file it.
Lordship.
In the meantime, if you file, ask the DC to file an additional affidavit by 2 o'clock, stating that. Else, I have to again hold the DC that she has categorically not mentioned. There was a specific direction passed in my order to explain why the affidavit was not filed. There's nothing mentioned. Ask the DC to file a short affidavit, 1 line or 2 pointing the figure at him. Then we'll take his statement and then initiate action against Mr. BJ Talukdar. Yes, Mr. Chatterjee, what did you think?
What had fallen from your lordship, my lord? I did have I'd taken instructions from my client, my lord. I bowed down what had fallen from your lordship, my lord. It was your lordship's.
Because if I say anything, it may be detrimental to your interest.
Yes. And while preparing myself, I had the occasion to go through the other cost papers of that ONGC matter, which we are trying to indicate to your lordship on the last day. I found that lordship was there in that matter when lordship was there in the bar when we were using the cost papers. So lordship is so well aware of the entire facts of the matter, madam. Only one
petition then.
Very well, very well. Only one is seeking. I was on seeking one indulgence, subject to what falls from your lordship, my lord, to have a observation to that extent that we need not initiate any steps for getting ourselves registered. It was done by the department suo. If that can be done, subject to what lordship considers.
Okay, we then make it a very simple order to that effect that you did not, but the state authorities did in terms with Rule 7(7) of the year, and as such, you would not like to press the instrument. I think with this, I think we can do this.
And any future cause of action arises, we have a liberty to come back before your lordship. If
Why?
situations were
What cause of action?
not in this
Mr.
respect, if
Chatterjee, you know, the cause of action factor is like this. If it is on the same cause of action, no. You
no,
don't need a
sir.
liberty if it is a separate cause of
Sir,
action.
I bow
Why
down. I
should I
bow.
mention them?
I bow.
Therefore,
I'm obliged, my
Mr.
lord.
B. Chatterjee, the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi, the learned appears on behalf of the Finance and Taxation Department of the Government of Assam. The petitioner herein have challenged the issuance of the registration certificate by whom? By the Superintendent of Taxes?
Yes.
Who has issued? Page
Page 76.
70. 7. By the
Office of the Commissioner of Tax.
Superintendent of Taxes.
Commissioner of Taxes.
The mail with which we were communicated indicates Department of Commissionerate of Taxes, Assam, at
Who has
page
issued this
70,
certificate?
well, page 74 at the bottom.
Superintendent of Taxes. By the Superintendent of Taxes, Government of Assam, under the Assam Taxation on Specified Lands Rules 1990. It is the case of the petitioner that the petitioner have not applied for the said registration. However, the said registration have been imposed upon the petitioner. And as such, the present proceedings have been initiated challenging the same. This court have duly taken note of. This court, during the course of the hearing, have pointed out to the learned counsel appearing on behalf of the petitioner, Rule 77 of the Assam Taxation bracket on Specified Lands bracket close Rules 1990, which permits the Superintendent of Taxes to register an owner who fails to apply for registration within a specified time. Taking into account the above, the counsel for the petitioner submits that the petitioner would not like to further press the instant petition. Accordingly, the writ petition stands closed.
I'm extremely obliged, my lord. It was really a pleasure appearing before your lordship. I take your lordship's leave.
Yes, thank you.
We have brought that.
Yes, Iola, is your firm is in dirt of paper that you are printing out this statement of claim placed before this court?
Wrong copy has been given, madam. I'm sorry, madam. No, I'm sorry. The wrong copy has been given. I have to show copy to Yes, yes.
There is a claim terms isn't there also there. Isn't there we have
Finally come to paragraph 13.1. 13.2 onwards.
page 34, my lord?
Hmm?
Page 34.
Page 32, 31.
Yes, ma'am.
Heard Mr. G. N. Sahiwala, the learned counsel.
Shouldn't that have been, said?
No, rejoinder, forget about rejoinder. You did not put it under without prejudice. You made it very clear. You have submitted. There is no quarrel that you can very well challenge this under 34. You can challenge it under the, but not in a 226. In view of the Supreme Court judgment, it is very clear. Because this court, if we start interfering with these, then there is no end of the matter. Heard Mr. G. N. Sahiwala, the learned senior counsel, assisted by Mr. D. Chanapoti, the learned counsel appearing on behalf of the petitioner. Who appears? Central government?
My lord, I'm appearing on behalf of Breach of
Where is he?
Report.
And Mr. B. Chakraborty, the learned central government counsel, appearing on behalf of the respondents. This court has taken up the instant writ petition The question arises in the instant proceeding as to whether
I don't know.
this court should exercise the jurisdiction under Article 2 to 6 of the Constitution. Or under Article 2 to 7, no, to exercise the jurisdiction under Article 2 to 6 oblique 2 to 7 of the Constitution in the present facts. For deciding the said, this court in brief would like to take note of the facts involved which led to the filing of the instant writ petition. The respondent number 2 herein to the respondent number 3 had invited a notice inviting tender for, inverted comma, construction of single line BG tunnel number 25 bracket APP dot total land 867 RM or KM. RM in bracket closed in between Noni and Tupul in connection with the construction of the new railway line project Jiribam dash Tupul Imphal of the NF railway construction. The petitioner herein was found to be eligible and was awarded the work by issuance of a letter of intent dated 13/10/2009. The petitioner thereupon, as per the contract terms, furnished the requisite performance guarantee in the form of an irrevocable bank guarantee in respect of the work mentioned. And thereupon, pursuant thereto, the contract agreement was entered into by and between the petitioner on 26/2/2010. While carrying out the said work for tunnel number 25, there was an allegation made by the respondent railway authorities that there was misalignment of both the ends of the tunnel However, the petitioner claims that it had duly rectified the said misalignment. And consequently, the tunnel number 25 apostrophe S, length was changed from 867 meters to 1382 meters. The petitioner claimed the extra cost amount, which was on account of the increase in the length of the tunnel, number 25, was paid to the petitioner by the railway authorities in the year 2016. Subsequently, on 26/2/2021, a letter was written to the petitioner wherein the petitioner was directed to deposit the amount of rupees 6,06,086, 6 crores 6,86,646.25 with the railways. Else, it was mentioned that the railway shall deduct the said amount from the already pending bills. This communication, dated 26/2/2021, was put to challenge by the petitioner in WPC number 2438/2021. While the said writ petition was taken up for hearing, the Standing Council of the Railways apprised this court that in terms with clause 64 of the general conditions of the contract, the dispute, the contract, there is an arbitration clause subject to the demand of arbitration clause, full stop. It was also submitted that as the matter would involve disputed questions of facts, the forum of arbitration as available under the general conditions of the contract would be an effective and efficacious remedy. It was also mentioned that for invoking clause 64 of the general conditions of the contract, the person aggrieved has to make a request the counsel appearing on behalf of the writ petitioner during the course of the hearing readily agreed to the said suggestion and submitted that the petitioner was ready to demand for arbitration as required under section 64(1) of the general conditions of the contract. And further submitted that till the issue raised in the writ petition is within the session SCISI of the arbitral forum, no coercive measures should be taken by the respondent railways on the basis of the letter dated 26/2/2021. The railway authorities, though, the counsel for the railways, though, objected to the same. But this court disposed of the writ petition at the motion stage itself, with a direction to the respondent railways not to initiate any coercive measures on the basis of the letter dated 26/2/2021 against the petitioner, subject to the demand made by the petitioner for arbitration within a period of 30 days from the date of the said order. 5/4/2021. It was also clarified by this court that the interim order shall remain in force till the dispute is in session of the arbitral tribunal or completion of the period of 30 days, whichever is earlier. And thereafter the same shall cease to operate. It is further seen that in pursuance to the said order dated 5/4/2021, passed in WPC number 2438/2021, the petitioner submitted a demand for arbitration in the same letter itself. It was mentioned that the general manager, in the said letter itself, a request was made by the petitioner that the general manager, bracket construction, NF Railway, Maligaon, should appoint an arbitrator who does not fall under any of the categories specified in the 7th schedule of the Arbitration and Conciliation, bracket Amendment Act 2015, for appointment as arbitrator on behalf of the Union of India and others, including the NF Railway. It was also mentioned that upon receipt of the communication from the general manager construction, the petitioner shall appoint their nominee arbitrator, and both the arbitrators so appointed shall then appoint a third and presiding arbitrator for constituting the arbitral tribunal. Pursuant to the said communication dated 29/4/2021, the general manager construction issued a letter to the petitioner whereby the general manager construction nominated 4 names of retired railway officers for formation of the arbitral tribunal. It is very pertinent to take note of the names of the persons who have been nominated, taking into account the dispute involved. Number one, the nominated arbitrators were, number one, Sri A.K. Mittal, who retired on 31/8/2017. Number two, Sri Radhashyam, ex-GM, Southeastern Railway, A.K. Mittal, ex-ME Railway Board, A.K. Mittal, ex-ME Railway Board, who retired on 31/8/2017. Sri Radhashyam, ex-GM / Southeastern Railway, who retired on 31/10/2015. Sri Akhil Agarwal, ex-DG / S&T / Railway Board, dated 30/6/2018. And Sri Harsh Kumar, ex-FANCAU / Northern Railway, who retired on 2/1/2014. The petitioner was asked to nominate at least 2 names out of the above of the list so provided for appointment of the arbitrator as nominee from the petitioner's side, so that further action, necessary action may be taken in the matter. The petitioner thereupon on 15/6/2022 sent a communication to the General Manager Construction, thereby selecting 2 names, namely Sri A.K. Mittal, EXME, Railway Board, and Sri Akhil Agarwal, ex-DG / SNT / Railway Board, and requested that an early action in the constitution of the arbitral tribunal may be taken, and the petitioner be notified about the same. Pursuant to the said communication dated 15/6/2022, the the Northeast Frontier Railway Construction appointed the 2 arbitrators who have been nominated by the petitioner, that is Sri A.K. Mittal and Sri Akhil Agarwal. And in addition to that, Sri Harsh Kumar as the nominee of the railways. Subsequent thereto, it is pertinent to mention that the petitioner had on 15/1/2023 submitted the statement of claim when did they file the subpoena? On 15/1, no, on when did you submit this? When?
In page 38, they've stated
Page?
on 12/9/2022, page 38 of the writ petition.
On 12/9/2022. So the statement of claim is not a part of the records of the instant proceedings. Now, as the statement of claim was not a part of the records of the instant proceedings, this court directed the petitioner to produce the state's statement of claim by an order dated 28/2024. And accordingly, the same have been produced today. A perusal of the said statement of claim do not in any manner challenge the constitution of the arbitral tribunal. Rather, paragraphs 13 and its subparagraphs do not challenge the constitution of the arbitral tribunal. On the other hand, a perusal of paragraph 13 and its subparagraphs of the statement of claim shows that the petitioner, without any reservations, had submitted to the jurisdiction of the arbitral tribunal. Paragraph 13(1) to 13(6) of the statement of claim being relevant is reproduced herein under. Page 30, 31. Subsequent to the statement of claim being submitted by the petitioner, the railway authority submitted the statement of defense. Thereupon, after submission of the statement of defense, the petitioner submitted an application on when did you do? 31/12/2022 for keeping the arbitration proceedings in abeyance in view of the fact that the judgment so passed by the Supreme Court in the case of Central Organization for Railway Electrification on the ground that the judgment of the Supreme Court rendered in the case of Central Organization for Railway Electrification versus ECI-SPIC-SMO-MCML (JV) reported in 2020-14 SCC 712 have been referred to a larger bench by the Supreme Court in the case of Union of India versus Tantia Construction Limited by an order dated 11/1/2021. It is under such circumstances the petitioner sought by the said application that the arbitration proceedings be kept in abeyance till such an issue of appointment of the arbitrator by the General Manager Railways is finally settled by a larger bench of the Supreme Court. This application, however, was rejected by the impugned order dated 31/12/2022. By the order dated rejected by the order dated 31/12/2022. And the petitioner was directed to file the rejoinder by 18/1/2023.
So that order is dated 6/1/23, my lord.
Huh?
6/1/23.
Where?
That order, the top, my lord, after the numbers it is given, my lord. Not, that is our.
Where is the, The said application dated 31/12/2022 was rejected by an order dated 6/1/2023. By the impugned order dated 6/1/2023. And the petitioner herein was directed to file rejoinder on 18/1/2023. It is under such circumstances the petitioner approached this court by filing the writ petition challenging the constitution of the arbitral tribunal by the letter dated 19/7/2022, as well as the order dated 6/1/2023 passed by the arbitral tribunal. In addition to that, the petitioner have also sought for appropriate directions upon the respondents to keep the arbitral tribunal in abeyance till the determination of the question by the Supreme Court. Today, during the course of the hearing, the learned counsel for the petitioner submitted that on 15/1/2023, the rejoinder was filed by the petitioner. In continuation to the directions so passed in the order dated 6/1/2023. Pursuant to the filing of the instant writ petition before this court on 30/3/2023, this court, by an order dated 3/4/2023, posted the matter on 24/2023 for consideration of the interim prayer. However, by an order dated, it is, be it as it may, it is only by an order dated 26/6/2023 the arbitration proceedings was kept in abeyance till the next date. An application was filed for vacating of the said interim order. However, the same was rejected.
Not rejected.
However, the same is pending. Is pending.
Rule. I think. On the understanding that the whole matter will be heard.
Huh?
On the understanding that whole matter will be heard.
The same is pending. This court further takes note of that an affidavit in opposition has been filed by the respondent railways. Wherein the principles, the stand taken primarily is that the petitioner, having already surrendered to the jurisdiction of the arbitral tribunal, now cannot make a U-turn and take a different view An affidavit in reply has also been filed. Reiterating the stand of the petitioner in the writ petition. In the backdrop of the above facts, when the matter came up before this court on 9/8/2024, this court raised the issue as regards the maintainability of the instant writ petition. And as such, gave an opportunity to both the parties to address this court on the same. The matter was heard on 28/8/2024, thereafter. Heard on 28/2024. And on that date, this court directed the statement of claim so filed by the petitioner be brought on record, as the same would aid in deciding as to whether there was, as to whether the petitioner herein had submitted to the jurisdiction of the respondent of the arbitral tribunal. In the backdrop of the above, the matter this court would like to take note of the submissions made by the learned counsels for the parties. Mr. G. N. Sahewala, the learned senior counsel, submitted that when the request was made by the communication dated 29/4/2021, pursuant to the order passed by this court on 5/4/2021 in WPC number 2438/2021, it was clearly mentioned that the respondents should nominate their own arbitrator, and the petitioner thereupon shall nominate, and both the arbitrators thereupon shall appoint the third arbitrator. They submitted that though the petitioner agreed to the nomination and thereby nominated two arbitrators amongst the panel so provided, but the appointment of the presiding arbitrator could not have been made by the general manager construction, as it would be in violation to the provisions of Section 12(5) of the Arbitration and Conciliation Act 1996, for short, the Act of 1996. He submitted that as per the judgment of the Supreme Court in the case of TRF, Limited versus Enegro Engineering Projects Limited, reported in 2017 8 SCC 337, as well as in the judgment in the case of Perkins Eastern Architects, DPC, and others, and another versus HSS HSCC bracket India Limited reported in 2020 to SCC 760. 760?
2020, 20 SCC.
2022 SCC.
20. 2020, 20 SCC.
20 SCC. 2020 SCC 760. The Supreme Court had been categorical in observing that a person who cannot be appointed as an arbitrator cannot also appoint an arbitrator. Full stop. If it is submitted that though in the case of Central Organization for Electrification, SUPRA, a three-judges bench of the Supreme Court
Voted in 2020, 14 SCC.
Huh?
2020, 14 SCC.
Which one? No, I've mentioned it. If it is submitted that though in the case of Central Organization for Railway Electrification, SUPRA, the Supreme Court, while interpreting clause 64(3) of the general conditions of the contract, opined that it cannot be said that the general manager had become ineligible to act to nominate the arbitrator. And held that the judgment in the case of TRF Limited, SUPRA, was not applicable. But the said view in the case of Central Organization for Railway Electrification have been doubted by another three judges bench of the Supreme Court in the case of Tantia Construction.
One on four. Page 114 and 116.
Tantia Construction. In the case of Union of India versus MS Tantia Construction, as by the Supreme Court in its order dated 11/1/2021, in the case of Union of India versus Tantia Construction, as well as in the case of JS, as well as by another order dated 16/8/2022 in JSW Steel Limited versus Southwestern Railway and another. And as such, the matter is presently pending before a constitution bench. He therefore submitted that the arbitral tribunal ought to have stayed the arbitration proceedings pending the decision by the constitutional bench on the said issue. He further referred to the order of the constitution bench dated bench in the case of Central Organization for Railway Electrification versus ECI, SPIC, SMO, MCML, bracket JV, reported in 2023 SCC Online SC 855, hereinafter referred to as the Central Organization for Railway Electrification, bracket 2. Anything else?
The Borpeta, I refer to our High Court judgment.
The learned counsel further, senior counsel further, referred to the judgment of the coordinate bench Borpeta or what? This one, no PCM.
Borpeta Agro Infra. Party. I'm giving another court matter. And Lombardy judgment also I refer to Malad. Lombardy judgment also.
What is Lombardy?
Lombardy Malad. Five judgments.
What does it say? He also referred to the judgment of the Supreme Court of a coordinate bench in the case of Borpeta Agro Infra versus Union of India, bracket arbitration petition number 51/2023, whereby the coordinate bench did not agree that the General Manager NF Railway would appoint an arbitrator in view of Section 12(5) of the 7th Schedule to the Act of 1996 and accordingly appointed an arbitrator to decide the dispute. What is Lombardy for?
2024 4 SCC 3341.
What is this for?
Also Malad section.
Huh?
I need section 12 Malad.
How is it relevant?
The point Malad, that is same thing. Paragraph 90 Malad.
Huh?
Paragraph 93, 97.
90?
90, 90.
Why is this required? For bias. Bias.
Same thing, my lord, the view of 12.5, my lord.
Nothing to do with the spirit.
Yes.
Your basic case is the matter is pending before the bench. So how does this judgment have any relevance?
He is not eligible.
Huh?
That is same thing, no? Just like TRF, my lord, is not eligible.
No, TRF is different. TRF is on the directly to the point.
Here also, my lord, that is there. Any person whose relationship with the party or any person, this would falls under category so and so 7 this shall not.
But here it is the retired, they are not relationship. Okay, let's not go into that.
Sure.
The Learned Council therefore summed up that the arbitral proceedings so pending be kept in abeyance till the final disposal of the issue, till the decision is rendered by the Constitution Bench in the case of the Central Organization for Railway Electrification, bracket 2. On the other hand, per contra, Mr. B. Chakraborty, the Learned Counsel appearing on behalf of the Railway Authority submitted. Yes, I've been all along submitting for you. What is your submission?
They have been surrendered, Lordship. The arbitration is initiated on the basis of their agreement, Lordship. This case has to be distinguished on that aspect, Lordship.
Huh?
Because whole process started from their own admission before this made before this court in the writ proceeding, Lordship. And thereafter they nominated we sent 3 names, they nominated 2, and the presiding officer also appointed from their own nomination, Lordship. It's not someone else that has been appointed. And I'll be relying on the Bhavan's case, Lordship.
Which case?
That exception is not a case of not made out a case of exceptional circumstances, so that the 227 can be invoked, Lordship. Twenty 1 SCC, Lordship. But your Lordship is other day papered, Lordship.
That judgment which I got it for you.
And in TRF, Lordship, perhaps that was in case of a sole arbitrator.
What is your submission?
The TRF case perhaps was the case of a sole arbitrator, and here is a 3 arbitrator, Lordship. And all retired, Lordship.
Per contra, Mr. B. Chakraborty, the Learned Counsel appearing on behalf of the petitioner, a respondent submitted that the petitioner herein, knowing very well the scope and ambit of clause 64 of the General Clauses Act, of the general conditions of the contract, had submitted before this court that it would submit itself to the jurisdiction of the Arbitration Tribunal, and accordingly duly applied before and duly made the request by the communication dated
29/4/21.
29/4/2021. He submitted that though in the communication dated 29/4/2021, the petitioner mentioned as to how the arbitrators were to be appointed, including the presiding arbitrator. But when the nomination of 4 arbitrators were made by the general manager construction, the petitioners not only submitted 2 names of their choice to be the arbitrator, but subsequently, in terms with the appointment of the arbitrators by the communication dated 19/7/2022, have submitted the statement of claim, that too without any raising any objection to the constitution of the arbitral tribunal or any demur. He submitted that it is a well-settled principle of law as held by the Supreme Court recently in the case of Union Territory of Ladakh and others versus Jammu and Kashmir National Conference and another, reported in 2023 SCC Online SC 1140, wherein the Supreme Court categorically observed at paragraph number 35 that it was not open unless specifically directed by the Supreme Court to await an outcome of a reference or a review petition. And it is also not open to the High Court to refuse to follow a judgment by stating that it had been doubted by the later coordinate bench. He therefore submitted that as neither in the orders by which reference was made to the Constitution bench of the judgment in the case of Central Coalfields, Supra, normal to, Central Coalfields, Supra. The question does not arise for the arbitral tribunal to await the decision of the constitutional bench, more so in view of the mandate of Section 29A of the Act of 1996. The Learned Counsel further submitted that in the case of Bhavan Construction versus Executive Engineer, Sardar Sarovar Narmada Nigam Limited, reported in 2022, 1 SCC 75, the Supreme Court had been categorical in observing that the exercise of the power under Article 226/227 ought not to be made of the Constitution, ought not to be made in respect to an arbitral proceedings unless in very exceptional circumstances. He therefore submitted that the incident with petition, therefore, is nothing but a proceedings filed with an oblique purpose, for the purpose of oblique purpose, in order to deprive the railway authorities of the amount which was oblique purpose to delay the arbitration proceedings and consequently deprive the petitioners, the respondent authorities, and delay the arbitration process, and consequently the interim order so passed by this court in its order dated 5/4/2021 in WPC number so and so can be continued. Come back. The parties at length and given my anxious consideration. The facts narrated above would categorically show that the petitioner in WPC number, that the petitioner in the earlier round of litigation, that is in WPC number 2438/2021, had duly agreed to submit to arbitration in terms with clause 64 of the general conditions of the contract. And on the basis thereof, this court directed the respondent authorities not to take any coercive measures on the basis of the letter dated 26/2021 against the petitioner, subject to the petitioner demanding for arbitration within the period of 30 days. The petitioner thereupon submitted before the General Manager Construction by the communication dated 29/4/2021 for appointment of appointment of the arbitrators in terms with section 64. In terms with clause 64. In doing so, the petitioner had categorically stated that the General Manager Construction should nominate its arbitrator. Thereupon, upon intimation, the petitioner would appoint its arbitrator, and the arbitrators jointly shall appoint the presiding arbitrator. Four names were forwarded by the General Manager Construction to the petitioner for appointment of an arbitrator. From the names as it appears in the communication dated 18/5/2022, the said officials have retired from the services of the railways. And the last one to retire was one Akhil Agarwal, dated 30/6/2018. This aspect of the matter was duly brought to the attention of the petitioner. And the petitioner was asked to nominate two arbitrators. The petitioner submitted a communication on 15/6/2022, thereby selecting two out of the four names and requested the General Manager Construction to constitute the arbitral tribunal. By notifying their names, addresses, contact numbers, and email IDs to the petitioner. Thereupon, on 19/7/2022, the arbitral tribunal was constituted. This communication was not challenged in any proceedings except the present one. The petitioner readily, without any objection, submitted to the jurisdiction of the arbitral tribunal by submitting the statement of claim. The relevant paragraphs of the statement of claim have been quoted herein above. The respondent thereupon submitted the statement of defense and it is thereafter on 31/12/2022 the petitioner for the first time submitted an application for keeping the arbitration proceeding in abeyance till the constitution bench of the Supreme Court decides in the case of so and so, HCRPO Central Coalfields number 2. A perusal of the said application do not, however, which have been enclosed as Annexure 13, do not, however. So there is a challenge to the arbitration proceedings, the constitution of the arbitral tribunal. Rather, it is a simple application for keeping the arbitral proceedings in abeyance. This application was rejected by the order dated 6/1/2023, which have been impugned in the instant proceedings. It is further seen that it is only in the instant proceedings that the petitioner have challenged the constitution of the arbitral tribunal. For the first time. Although it is the mandate of the Act of 1996 to challenge the arbitral proceedings in terms with Section 16. Now the question therefore arises that is this a case of exceptional nature that this court should exercise its jurisdiction under Article 2 to 6 of the Constitution? More so, when the Arbitration Act of 1996 is a complete code by itself, dealing with the arbitration proceedings. And thereby granting the autonomy to the arbitrators, arbitral tribunal to decide the procedure. This court also finds it very pertinent at this stage to take notice of Section 29A of the Act of 1996, which is a statutory mandate imposed upon the arbitral tribunal to complete the arbitration proceedings within a time frame. And failure to comply leads to consequences. Thereby, the arbitral tribunal loses its jurisdiction. The so constituted loses its jurisdiction. This court also finds it very pertinent at this pertinent to take note of Section 34 of the Act of 1996 which stipulates that the recourse to a court against an arbitral award can be made only by an application for setting aside the said award in accordance with subsection 2 and subsection 3. Amongst the various grounds, amongst the various, section 34(2)(a) Roman 5, A2 small a, Roman 5, provides the ground for challenging the arbitral award if the composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties, unless such agreement was in conflict with the provisions of Part 1, from which the parties cannot derogate, or failing such agreement was not in accordance with Part 1. This court further finds it relevant to take note of section 37, which specifically relate to appellate orders. Amongst the various orders which can be assailed under section 37, an order by which a plea referred to in subsection 2 or subsection 3 of section 16 is accepted however, in the case of not accepting a plea under section 6, subsection 2 or subsection 3 of section 16, the only challenge can be made by way of section 34. This court cannot also lose sight of section 5 of the Act of 1996, whereby the judicial interference in respect to matters which are otherwise not excluded specifically have been statutorily injuncted. In the case of urban constructions, And again, in the case of Deep Industries Limited versus ONGC, reported in 2020-15 SEC 706, the Supreme Court, while taking note of the interplay of Section 5 of the Act of 1996 with and Article 2 to 7 of the Constitution, observed that's taking into account Section 5 of the Act of 1996, Section 37 grants a constricted right of first appeal against certain orders, judgment and orders, and none others. It was also observed that if writ petitions were to be filed under Article 2 to 6 oblique 2 to 7, the entire arbitral process would be derailed and would not come to fruition for many years. FRUITION. It is further observed that though the constitutional provisions of Article 2 to 6 and 2 to 7 of the Constitution are of wide amplitude, yet the High Court should be extremely circumspect in interfering with the same, taking into account the statutory policy as adumbrated by the legislature, so that the interference is restricted to orders that are passed which are patently lacking in inherent jurisdiction. Now, coming to the judgment in the case of Bhavan Construction Supra, the Supreme Court opined that the High Court erred in utilizing its discretionary powers available under Article 2 to 6 and 2 to 7 of the Constitution in the said proceedings. Primarily on the ground that the petitioners therein duly submitted to the jurisdiction of the tribunal, arbitral tribunal, by submitting its statement which alike the instant proceedings. Which is alike the instant proceedings. In view of the above, this court is of the opinion that the question of exercising the jurisdiction against the order dated 6/1/2023 by the arbitral tribunal under Article 2 to 6 or even under Article 2 to 7 of the Constitution is not called for in the instant proceedings. More so, in view of the statutory mandate in terms with Section 29A of the Act of 1996, which statutorily obligates the arbitral tribunal to complete the arbitration proceedings within a time frame. In view of the above, let this court take up the next issue as to whether the petitioners herein were at all justified in seeking the proceedings, thinking that the proceedings of the arbitral proceedings should be kept in abeyance before the arbitral tribunal. For that purpose, we find it relevant to take note of the judgment in the case of Union Territory of Ladakh, Supra, wherein the Supreme Court, at paragraph number 35, wherein it was categorically observed that the high courts, wherein it was categorically observed in the context of High Court not deciding cases on the ground that the leading judgment of the Supreme Court in the subject matter is either referred to a larger bench or a review petition relating thereto is pending. Observe that the High Court should proceed to decide matters on the basis of the law as it stands. It is further observed that it is not open unless specifically directed by the Supreme Court to await an outcome of a reference or a review petition, as the case may be. Paragraph 35 of the said judgment is reproduced here in below. In the backdrop of the above, if this court duly takes note of the submission of the learned counsel appearing on behalf, senior counsel appearing on behalf of the petitioner, it would be seen that the petitioners have sought that the arbitration proceedings should be kept in abeyance in view of the fact that two subsequent three judges benches of the Supreme Court had doubted the decision in the case of Central Supra and number 2 no Supra. It is relevant to take note of that the perusal of the judgment in the case of Central Organization for Railways Supra the three judges bench of the Supreme Court categorically observed that the decision in TRF Limited is not applicable as regards the interpretation to be made in respect to clause 64(3) of the general conditions of the contract. This judgment have only been doubted and referred to a constitution bench, but not overruled. It is also apposite to take note of that in TRF Limited, clause 64(3) of the general conditions of the contract was not an issue. Rather, what was an issue was clause 33 of the general conditions of the purchase order. And this aspect have been clearly distinguished by the Supreme Court in the case of Central Organization for Railway Electrification, Supra. Therefore, taking into account the judgment in the case of Union Territory of Ladakh, Supra, this court finds no ground to interfere with the order dated communication, the constitution of the arbitral tribunal dated 19/7/2022, as well as the order dated 6/1/2023. This court also, taking into account the statutory mandate contained in section 29A of the Act of 1996, also finds no good reason to stay the further proceedings of the arbitral proceedings pending the dispute, pending the issue being decided by the Constitution bench in the case of Central Area bracket 2. Accordingly, the interim order stands vacated, and the instant writ petition being devoid of any merit stands dismissed. Next. Before parting with the record, this court, however, observes that the observations so made herein above shall not affect the rights of the petitioner to take the ground under section 34 2F 2V 25 of the 2A5, 2A bracket 5 of the Act of 1996. If so advised, তাতে আৰু এটা লিখি লৈছো আৰু এটা কৈছো this court আৰু এটা paragraph is fine. The learned counsel for the senior counsel for the petitioner have referred to the judgment of the coordinate bench in the case of Borpeta Agro so-and-so Supra. However, the said judgment would not be applicable to the present proceedings, taking into account that the said judgment has been rendered in the proceedings under section 11 for appointment of an arbitrator. Whereas in the instant proceedings, the petitioner have already submitted to the jurisdiction of the arbitration tribunal by submitting the statement of claim.
They are not appearing, Lord.
After that,
This is the third consecutive day.
after that issue, when you brought the
That
GMC,
notification, yes.
it is within the GMC.
No, in fact, Lordship, the counsel who engaged the learned senior advocate, he informed the senior advocate that they are no more in a position to pursue the matter, Lordship. Probably they are not.
We do one thing. We put it non-appears dismissed for default.
Lordship. Because this is the third day, Lordship.
Because this is the third day this is happening. Because this happened because of that, when you came up, no, it was initially, Paschim Boragam was initially there in the GMC.
In the year 73 itself.
73. So that is why everything changed. None appears on behalf of the petitioner on call. Mr. P. Nayak appears on behalf of the respondents. Taking into account that the petitioners have not represented on the earlier occasion also, this court dismisses the instant with petition for default. Yes, what is it? What happened? Election done.
The
18-8.
sometime my senior.
Election.
My lord, in fact, not held because your lordship, this honorable court directed me to obtain the instruction as to why, my lord, the nominations, what happened to the nomination. But as per the report, my lord, nobody turned up, my lord, to tender the nominations, my lord. Accordingly, my lord, nomination, my lord, there was nobody.
Did you wait for that period?
Yes. it
Or did you
appears-
leave at
yes.
12 o'clock?
No, it appears that up to 1 p.m. they remained there. my lord. This time, my lord, up to 1 p.m.
What happened in that case? None election.
Same
was
case,
also-
my lord, same case.
Same case.
Yes,
Where I passed that order.
yes, my lord, same case. Your lordship's order
That
is
is
for,
what I said.
yes, your lordship's order is annexed, my lord.
Then also they did not turn up.
In that case, my lord, notice was pasted before expiry of the time. Here, my lord, it says, my lord, that nobody turned up, my lord, to tender the nomination, my lord. As per the report.
No. This is this the same one?
Same case, my lord, Jamadar Hat. Same cooperative society. Pursuant to your lordship's direction, my lord, which was passed on 5/8. Accordingly, notice was issued, my lord. Returning officers were appointed and the date for nomination was fixed, my lord. On 8. On 8, my lord, nobody turned up as per the report.
Then?
Then, my lord, now election could not be held. One man, my lord, has been, this is my lord, one-man committee. On expiry of 18, my lord,
17, page 15. Paragraph 17, page 15. उसमें kindly करें. What happened on that day?
Why it is in 3 cases, 3 different councils? The first was somebody else.
Yes.
What was his name? MJ Kadir. Then comes Mr. JMA Chaudhary. Now Mr. Saikya. Something is somewhere wrong somewhere.
On 17, on 7/8, my lord, the notice was issued by the authority, my lord. And on 8/8, my lord, this happened in paragraph 17, I have stated. 15 persons, they collected nomination papers, my lord. They were ready to submit the nomination papers. Some disqualified members who did not attend the my lord, AGM for last 2 years, they were disqualified. They, my lord, came and my lord protested before the authority not to accept the nomination papers. And accordingly, my lord, nomination papers was not accepted. It was informed to the higher authority immediately, my lord, about telephone. But they did not take any action, my lord. And their only intention was to, my lord, run the society by a one-man committee. That's their only intention, my lord. From the last 3 cases, we will, my lord, come to know that how they are delaying the process of election, my lord. Their only aim was to,
Anyway, let's do one thing. You file your affidavit. One-man committee has been appointed. One-man committee has to, as per 41(6), is to hold the election within 90 days. So 90 days have already started.
From 19.
our case is that,
19.
my lord,
So you start your process, whatever. may be. Go ahead. Because you see, it is beyond what, if you want to go much deep into this, these are all disputed questions of facts. Initially, the first one was,
for extension.
it
of
was
the-
cancelled. No, it was cancelled. First
First notice was cancelled.
First one was cancelled. I intervened. Asking them, they say that because of floods, we are not in a position to hold. Kindly give us some time. I said, nothing doing. Floods have gone, now hold it. Fixing a date on 10/8. Easy.
On or
10.
Yes, yes.
10/8. I remember 10/8 when I fixed it. And they said that okay, because they have already passed a resolution some time back that they are going to hold. So as such, asking you to go ahead with the issuance of notice. Notice was issued, then they have also issued the notice. The Eastern Register of Cooperative Society has also issued that notice. Then your claim, some of the persons claim out here is, look here, what has happened is, before even receiving it, before the period of 1 o'clock being over, we have received the scanner. The scan copy we have received at 12 o'clock and they have
Cancelled.
closed it. So I said that nothing doing. Then again, I extended by another 10 days because you need a 10 days notice. Now, as of now, 18/8 period of 5 years is over. So one-man committee has been appointed. Therefore, the question is, this one-man committee has to do it within 90 days. That is the only way out.
Toshib has directed the authority, my lord, to hold the election on or before 18/8. The election process be, my lord, within a very short time, my lord. they-
How?
Already, my lord,
We
persons.
will
we
look
have
into
parties
it, but
that-
if they have made a mistake now, this is the case for them to file an affidavit. Bring on record this as to whether it is there. Let that person, you say that it was, you have cancelled, they have cancelled it. They did not accept. You went to submit the nomination, they did not receive.
they did not-
Who did not receive?
Officials of the, my lord, cooperative department, my lord, from response number.
There were two. One is a returning officer, he did not receive it.
My lord, I have named him.
This time there are 3, my lord. At page 93, if your lordship sees, my lord, 4th line from the top, this is the notice, the order passed, my lord, pursuant to your lordship's, my lord, order. One, my lord,
Page,
page 93 of the writ petition, my lord.
7, my lord.
That this is the order of the, my lord, register, Eastern Register. One, my lord, Horeram Roy, senior inspector, he has been appointed as returning officer. Another Prantik Setia, senior inspector, and Orindam Bhattakur, senior inspector, they are the assistant returning officer.
for receiving the nomination
Nomination
papers
papers.
from the contest to be
Right.
held on so-and-so, at so-and-so, and withdrawn to be held on so-and-so, and also the AGM to be held on month so-and-so. So-and-so is so-and-so, and so-and-so, so-and-so are appointed as observers. Now, whether the observers will only observe at the election,
Yes.
not before that.
My lord, in fact, entire process, my lord, they will observe.
So,
Yes.
They were required to observe the nomination.
Have you made the observer a party? Okay, let the observers,
no, I
we have to issue notice then, because in view of the allegation, who are the observers?
Observers are my lord, one Mobinul Haq and Soidul Alam. Soidul Alam has been appointed as the my lord, head of the on.
Okay. Let them file an affidavit also, what is it actually, they observed what? Okay. Issue notice making it returnable on 23rd of September 2024. Mr. So-and-so accepts notice on behalf of the respondent number 1, 2, and 3. Post. Petitioner is taking into account that Mr. Talukdar represents on behalf of respondent numbers 1, 2, and 3, extra copies of the petition be served upon them during the course of the day. As regards the respondent numbers 4 to 9, the petitioner is directed to take steps by way of registered as well as by usual within 3 days. Trustee. In addition to that, the petitioner is also directed to take steps. In addition to that, as the petitioner has expressed urgency in the matter, petitioner is permitted to take steps by way of dusty upon the said respondent numbers 4 to 9. The case of the petitioner herein is that this court, by an order dated 5/8/2024 in WBC number 3924/2024 had directed that the AGM directed that the petitioners to issue a fresh notice by 6/8/2024, thereby fixing the AGM as well as the election on or before 18/8/2024. It is a further case of the petitioner that the petitioners thereupon have issued the notice and issued notice on 6/8/2024. And on 7/8/2024, the Eastern Register of Cooperative Society have also issued an order, thereby fixing 8/8/2024 as the date for submission of nomination from 10 a.m. to 1 p.m. It is the further case of the petitioner that the respondents, that the petitioner though tried to submit their nomination, but the respondent authority did not accept.
Pending candidates,
But certain, though the petitioner wanted to submit the nomination, but the intending candidates did not. Some shareholders did not permit the petitioners to submit the nomination.
pending candidates wanted to submit the nomination papers. Some disqualified members my lord, did not permit them to submit the nomination.
It is the case of the petitioner. Are you those petitioners?
No.
Then who are you?
Society.
Society, what does it have a business?
And the society my lord, who wants.
Why those intending members have not come?
But the society wants a general, my lord, democratically elected committee.
Understood, but why none of the intending members are before this court?
The petitioner number 2, my lord, he was also one of the intending candidate, my lord.
It is the case of the petitioners that the petitioner number 2, along with some other intending candidates, wanted to submit the nomination, but the respondent, but the certain disqualified members did not permit them to submit. And consequently, a one-man committee has been constituted on 28/2024. The petitioner submits that the the elections be duly held as per the mandate of law, and as such has approached this court. This court have also duly taken note of the provisions of section 41(6) of the Assam Cooperative Societies Act 2007, which mandates that the one-man committee is required to complete the election process within 90 days from the date of his appointment. On the returnable date, the respondent authorities shall place before this court what further steps are being taken for holding the elections.
My lord, before writing, your lordship has finished this item, my lord.
Eh?
This order is finished, my lord. Item 11, my lord, in fact, what I'm trying to say, my lord, there was an order for, my lord, listing as top of the list. But the cause list does not reflect whether your lordship is taking up at 2 p.m. or your lordship will take up seriously.
But 11, what is the matter about?
The election, the one-man committee, one man has been running the affairs of the committee since 2 years now, since 2022. There was election have been challenged.
What is being challenged?
They have challenged the. setting
That
aside-
matter, my lord, that
That was the
Bonik had
register.
argued, Rule 27 cannot be bypassed, my lord.
Oh, yes, yes.
That
Yes.
matter.
Lordship, I pray, Lordship, will take up at 2. It was a top of the list matter today. It did not reflect in the cause list.
I've been taking only the top of the list matters only now.
So it is.
Only the motion was not there. Otherwise, all are top of
No,
the
it is
list.
correct, sir. It is reflected in the order, my lord. That is why I'm trying to understand, my lord. Whether it will go serially or lordship will take up, my lord.
Okay, we take, if it is there in the top of the list, we'll take it.
Yes.
It is not reflected in the cause list, that's why.
It is in
That
the
matter doesn't take time. It is only the question as to you have, if you want to challenge an election, it has to be done in accordance with that, nothing more than that. That day I passed an order also, na? In another case, you had appeared, remember? Where Mr. Bonik was not showing the judgment of Justice Dave.
Oh, yes. But here he has developed an argument, my lord. So
Here he is.
I have to
here.
counter it, my lord.
Uh,
Yes.
he-
Because the only question is whether there is a repository of power under the scheme, my lord. That, my lord, perhaps that issue, my lord.
No, the
would require-
issue out here is, in view of the election process having been started, and can the register on its own decide it?
There is in the rules. He has the power. In the rules. The-
An election dispute.
Yes,
That's it.
yes, Lordship.
That's
The
the-
rules give the power, Lordship. And
Yes, Mr. Hazarika, you are also waiting. Your matter is 12. Okay, we'll take it after that. Where is your advocate general will appear, I suppose. They have filed affidavit?
I have filed an affidavit, but I believe it's.
Okay, after this matter, I'll take it. This matter won't take much.
Supplementary list 1 for judgment pertaining to Kohima bench. Item number 1.
Okay.
20 second. 20 second.
Yes, Mr. Counsel. In view of the judgment in Nisibi, assuming I am dismissing your petition, huh?
For 2 and 3.
Flush.
Mr. Jamil, I have taken into account the submission of Mr. Advocate General, wherein it says that the two office memorandums operate in two different fields.
Lordship.
And accordingly, holds that you don't come under the 17-3-2015, but however, you are to be considered in terms with 22-9-2004.
Lordship.
In addition to that, this court has also made it clear that you have the petitioner in WBC number 105/2020 is at serial number 8, and the petitioner in the other writ petition has serial number 4 of the list.
Lordship.
And accordingly, this court has directed the respondent author to consider the case of the petitioners in terms with the subclause 4 of the office memorandum dated so and so. This court further observes and directs that the respondent shall not violate the quota of 50% of all future vacancies as stipulated in clause 3 of the office memorandum dated so and so. In addition to that, the respondent authority shall not make any fresh appointment in violation of clause 4 and clause 5 of the office memorandum dated so and so. Further observed, the petitioner herein would be entitled for consideration in terms with the office memorandum dated 17-3-2015 only upon completion of 30 years of service.
Lordship.
I've also dealt with clause number 5, which stipulates that you cannot violate, you cannot appoint anybody falling within the quota of 50% without first ascertaining that there are no work charge employees, and secondly, that there are without taking the permission of the PNR department.
Lordship. Much obliged, Lordship.
Item number 4.
Madam, in this case, the petitioner have already completed around 34 years of service. And as such, this court have directed that immediately within 2 months, the state should regularize your services, else it may result in a lot of complications, not only depriving the petitioner of the regularization, but would also lead to problems as regards the pensionary benefits. So therefore, I've directed to do it within 2 months.
Item number 5 and 6.
You're there in this item number 5 and 6? Okay. The challenge made to the various clauses of both the office memorandums which were there have been rejected, including the question of granting you the equal pay or minimum scale of pay which is being given to the regular employees is also rejected in view of the judgment of the Supreme Court in the state of Bihar versus Bihar Teachers Struggles Committee, which stipulates that not only the ground of the manner in which a recruitment is being made is a very relevant consideration. However, you would be considered as you are already at serial number 96 and 97 when your turn comes. Okay.
Timing item 3, principal sit.
We are filing an affidavit. Kindly accommodate me for 10 minutes time.
What you are filing?
We are filing the affidavit, Mulad. An
Additional affidavit?
An additional affidavit is being filed, Mulad. Kindly accommodate me for 10 minutes time.
No, you see this affidavit which you have filed,
Mulad.
you say 1 Katha 17 lectures of land is found in the FCI.
Mulad.
Of these 7 lectures of land have already been acquired.
It is covered in the earlier LA case number 3 of 12.
Not earlier, not the first one, the second one.
The second.
So why you are again demarcating and finding out that 1 Katha 17 lecture by making a demarcation?
Mulad, the total land of the petitioner is 2 Katha. Mulad, out of 2 Katha, 3 lecture she is having outside the boundary. To 1 Katha 17 lecture she is claiming for compensation. After demarcation, pursuant to Lordship's order on 8th of August, we have demarcated the in presence of the petitioner. We found that 1 Katha 17 lecture land is within the campus, FCI campus. FCI is denying that they are having any land. But after demarcation, we found, and also it is revealed from the record, that's out of 1 Katha 17 lecture, 7 lectures of land is already it is there in the earlier LA case. So 1 Katha 10 lecture land of the petitioner as on today, is within the campus of the FCI. So if therefore we have Lordship has directed us to make this stand clear in our affidavit. We have said that since the land is required for the FCI and it is handed over to them, and therefore for the 1 Katha 10 lecture land, either we have to go for the acquisition or.
But has the FCI requested you?
No, if they say that we don't need the land, then we have to take it out and give it to.
No, FCI is very categorical that we have not requested that.
There is
Because you have earlier also given an offer to the FCI to make an outright purchase.
There is a difficulty, that FCI is possessing the land since 2007, and within their campus, they are satisfied with whatever land they have. But the thing is that the acquired land is 202 biga at the first in 2007, 7 biga land in 2012. But they are possessing access land. Since the land is within their campus, now they said that they are not approaching, they're not coming forward either for purchase or for acquisition. Ultimately, the thing is that the petitioner's land is within that. If they said that we don't need the land, that stand has not yet come, because in our affidavit we have made it clear that we have to go for fresh acquisition if the 1 Katha 10 lecture land within their campus is required by them. That we have made it clear. If they say that no.
No, why
don't-
do you have to go for acquisition?
but, either.
No, no.
We have to take it out. We have to take it out.
Is the state government machinery is such that it will just acquire without even the requiring authority asking? you?
No,
Then
since it is within their campus, Lord, and they need the land, they have not.
they
said-
need the land. Who are you to say? They are not telling you
No,
that we need the
Lord,
land.
Lord, in fact,
They categorically say that this is our land.
Lord, they have not, that is what, Lord, they said that is our land and they need the land. Lord, since the access land is there, they have to either Lord, they have to relinquish or they have to give it.
No, Mr. Nath, if you are aware, earlier there you have many times requested them for going for an outright purchase.
At that point of time, I think, Lord, there is one difficulty because we said that 1 kata 17 lecha land you purchase. As per record, Lord, 7 lecha is already included, so they have to go for 1 kata 10 lecha. Lord.
But whatever may be, they categorically say in their communication to you that look here, this is the part of the land which have been acquired and handed over back to
Yes.
possession.
That is their stand.
So here is a case where the state have handed over possession of more land to the petitioner, to the FCI.
FCI.
So if you have done it, you have not followed the process
Yes,
of law.
Lord, since Lord, we have discussed it, Lord, since the land is with them, if they require, they can proceed or they can instruct us to proceed with that. If they don't proceed, Lord, they don't need the land, then we'll take back the land and hand it over to the petitioner.
How?
Ultimately, 1 kata 10 lecha land.
How?
Access.
How are you going to hand over?
Lord, from the FCI, Lord, we have to take it out. Lord, the demarcation is already there. We have come. to the-
Demarcation is there for 1 kata 17 lecha. That is why. I'm saying.
10 lecha land we found.
No,
access in- in-
no. Kindly see your demarcation in your affidavit. As per the field verification dated 16/8/2024, it was found that 1 kata 17 covered by land belonging there falls within the boundary of FCI. This is your demarcation.
Yes,
You have not demarcated 1 kata 10 lecha.
1 kata 17 lecha.
In spite of knowing that this 7 lecha is a part of that their acquisition. You have not done that.
In fact, it is.
This was done only pursuant to this court passing an order. Then also you have done 1 kata 17 lecha.
But it is contiguous, Lord, bearing 7 lecha for 1 kata 10 lecha, we have to take the action. Because the 7 lecha falls in the land acquisition process, and for that they have also deposited the amount.
That is one. Second, why have you kept that money of 7 lechas
Lord,
with you?
That I find,
Unless
Lord,
the petitioner would not have filed, you would have misappropriated.
no, but the amount is still lying with the treasury. Lord.
Why?
It is on record.
Why?
But the petitioner is insisting.
Who is
that-
going to pay now the interest? You are to pay the interest.
But what has happened, Lord, what I find from the record, Lord, but the petitioner is insisting for land acquisition compensation for 2 kata land. That is why possibly the 7 kata,
I-
7.
I'm not on that. I'm asking you, why did you not pay him the 7 lechas?
But, from the
7 lechas have been acquired in 2012. Who is going to pay the interest?
that is
Will be entitled to interest at the rate of 15%. Who is going to pay? The state or the officials?
that Lord,
Recover it from the officials, from their salaries.
but I'll specifically talk to that Lord, why it was not offered.
No, it can't be. It is a case of misappropriation by the state.
It is in the account, Lord.
Huh?
It is still there.
So you can't say that the 56,000 we have just kept it with myself. If the petitioner would not have approached,
The petitioner is approaching, that is where the difficulty.
by applying the doctrine or acid,
No,
then
the petitioner is.
yeah, there
approaching
is a
for the
person who is
kata.
claiming all the rights all along and you are doing this. Thirdly, why the affidavit was not filed?
But,
There was a direction to file.
well, in the additional affidavit, we have explained.
Right.
But on 18/3, Lordship has passed the order. On 24/4, some instruction has come. But the government advocate who is appearing in the matter of law, he said that this instruction is not clear. You have to give us specific instruction. On 27/4, my lord, we have received a letter that because of the ensuing election, they need some time. It was at that time, my lord, election was there. And my lord, subsequent on 2-3 days, my lord, the case was listed. And on the prayer of the learned government advocate, my lord, honorable court granted time. In the meantime, the instruction has come and the affidavit was also shown by the DC Malad, and it was sent to the London Government Advocate on 6th of August. The case was fixed on 8th of August. But somehow, Malad, because of some personal difficulty on the part of the council, the affidavit could not be filed. And it was filed, Malad, I have checked, Malad, on 14/8, Malad, it was filed. But in the meantime, Lordship has passed the order of 8th of August. In the 8th of August, Malad, some more directions were there, Malad, some more information were sought. So that affidavit, Malad, we have filed today.
Where is the 14/8?
14th
Affidavit?
affidavit we have filed. Malad.
Where?
But I have a copy in the affidavit on record, it will be there, Malad.
14/8?
It is page 23, Malad.
Page?
Page 23, serial number 23, Malad.
Huh? Page?
It starts at page 23, Malad.
20,
Page 23.
14th August.
Page 23 to page 27. It was, Lordship will find the sworn on 6th of August.
There is no mention of the 7 lectures.
Malad, 7 lecha they have mentioned, Malad.
Where?
No, Malad, at that point of time, Lordship was directed on 8th of August to go for a demarcation. After the 8th of August, Malad, the demarcation was done, and on 20th.
No, why was the occasion of filing this affidavit arose?
Because
The occasion arose
of the
because they came up with a specific stand that 7 lessons of this particular dag was acquired by the LA case number 3/2012. Where is your answer?
But it was not there because at that time it was not there.
Just filing an affidavit for the sake of it. You are saying the same thing. 1 Katha 17 lesser.
Well, in the affidavit filed today, here, Malad, we have stated, Malad, clearly. And Malad, I have the records, Malad. From the record, I could find.
This matter would have been finished last year when I passed the order on 26/7/2023. Thereafter, nothing happened. When I took up this matter again on 8/8/2024, only things came up. Otherwise, the government advocate has been taking time after time. Is this the manner in which the senior counsel or the government, whoever appearing 6th time?
That Malad, I have taken note of, Malad. It will.
You are the senior government advocate. Don't hand over these cases to these officials who do not see the mandate of the advocate.
I'll take care of it.
Now, as of now, you don't have a demarcation of 1 Katha 10 lecha.
Malad, in the report, Malad, they have indicated that in fact,
the report is there, page annexure
Yes,
A, page
I
32.
have
It does not say anything. It says about 1 Katha 17 lecha.
1 Katha 17 lecha out of total land of 2 Katha of the petitioner. That they have said. But
We are only concerned with 1 Katha 17 lecha,
Correct.
of which 7 lecha was been already acquired. 7 lecha, how much it would be with interest at the rate of 15%? You find out, we take it up next week on 27th.
Alright.
Find it out, how much it would be. And secondly, Mr. BK Singh, if you are not willing to take it up, we ask them on next date to vacate it.
Sure. Sure, Malad.
I will be agreed with
Sure.
the instruction.
We ask him to immediately to give it back.
Yes.
There is no question of acquisition unless they request.
Yes.
And if it is an acquisition, it has to be done in terms with don't go for this requisition business. This can't be for a requisition. if it is an acquisition. Now, the third thing is, who is going to pay the loss or the mean profit for the period from 2012 till date? He has been holding it is a state authority. They have to pay that.
Since they are positioning, they have.
They have to pay
they
that.
have- they have-
The requisition expenses. Not that they have, certain mean profit has to be paid and won't be put it as a requisition expenses. It's a mean profit, how much it would be. They have to pay. You may do it in terms with the Assam Land Requisition and Acquisition Act. There is a manner in which it is given. You have to finalize it and give it to. Yes. Since right under 300A has gone for a toss. Pursuant to the order passed by this court on 8/8/2024, it is seen that 2 affidavits have been filed by the district administration. The first affidavit is of the year was filed on 14/8/2024 by the district commissioner, Kamrup Amingaon. In the said affidavit, although there was a specific direction to clarify, taking into account the affidavit filed by the FCI, the respondent, the district commissioner continued to mention that a portion of land measuring 1 katha 17 lecha out of 2 kathas of dag number 1693 of KP Pata number 331 of village Sangsari under Sila Sinduri Ghopa Moja is under the possession of the FCI. And the same is within their boundary. Thereupon, another affidavit was filed on 22/8/2024. In the said affidavit, an enclosure have been a communication issued by the circle officer to the additional district commissioner dated 28/2024 have been enclosed. From a perusal of the said communication, it reveals that as on 16/8/2024, it was found that 1 katha 17 lechas covered by dag number 1693 part of KP Pata number 331 belonging to village Sangsari falls within the boundary of the FCI Sangsari. Be it as it may, the affidavit dated 22/8/2024 addresses the issue which was raised by this court by the order dated 18/3/2024. Inasmuch as it seems that the district administration have then realized that 7 lechas of land belonging to the petitioner was acquired in connection with LA case number 3/2012 and the FCI had already deposited the amount of rupees 64,35,829 for 7 bighas, 2 kathas, 9 lechas of land, including the 7 lechas. It is also mentioned that an amount of 54,670 is still lying in the treasury. And on a specific query being made, it is been mentioned that the said amount pertains to the 7 lessors which is yet to be disbursed to the petitioner. Taking into account that the acquisition proceedings was initiated in the year 2012, and that too under the provisions of the Land Acquisition Act 1894, which mandates as per section 34 that the interest has to be paid at the rate of 9% for the first year from the date of taking over possession, and after the expiry thereof at the rate of 15%. This court inquired with the learned senior government advocate, Mr. D. Dant, as to how much amount would now have to be paid to the petitioner. On the ground that the amount of rupees 54,670 was not neither tendered to the petitioner at any point of time. This court had also inquired as to whether the same would not amount to the dereliction on the duties of the officials concerned in not tendering the amount of the 54,670 to the petitioner. More so, when now the state respondents, the district administration, has to pay from its coffers the additional amount on account of interest. After all, the said amount which has to be paid from the public funds, exchequer. Mr. D. Nuts, the learned senior government advocate, submitted that he would make necessary inquiry as regards the amount to which the petitioner would be entitled to, along with the interest. On the next date, and also provide details as to when the said amount would be paid positively. The second question which arises in view of the affidavit so filed by the district administration, the district commissioner, is an area of 1 katha 10 lichas of land is still within the campus of the FCI Sangsari. That is the respond number 5.
Here 4 and 5.
4 and 5. And there is no documents shown before this court which would suggest that this area of 1 katha 10 lichas of land have been acquired. Though the learned senior government advocate had submitted that the state government would acquire the land and pay the petitioner the compensation. But the question arises as to whether the state government, at whose instance would the state government acquire the land? More so when there is no materials on record to show that the FCI, that the respondent number 4 and 5 have at all sought for acquisition of the land. Be that as it may, this is the classic case where there is a violation to the provisions of violation to the constitutional mandate of Article 300A of the Constitution, whereby the petitioners' land admeasuring 1 katha 10 lichas have been taken away by the district administration and handed over to the FCI, which is also a state within the meaning of Article 12 of the Constitution. Therefore, without the acquisition of the said acquisition of right in respect to the 1 katha 10 lectures of land in accordance with law, both the district administration as well as the FCI cannot be permitted to retain possession of the said land. Mr. B.K. Singh, the learned counsel appearing on behalf of the respondent number 4 and 5 submits that he will obtain instruction as to what the respondent number 4 and 5 shall do in view of the developments which could be seen from the affidavit filed today by the Deputy Commissioner, District Commissioner, Kamrup. List the matter on 29th of August 2024, on which date Mr. D. Nath, the learned senior government advocate, shall apprise this court as to what would be the amount now payable to the petitioner in respect to the 7 lessees of land in view of the interest as statutorily mandated, and as to when the said amount would be paid to the petitioner. The senior government advocate shall also seek instruction as to who were responsible, which led to the non-tendering of the amount of rupees 54,670 to the petitioner. Mr. B.K. Singh shall apprise this court on the next date as to whether the respondent number 4 and 5 would like to retain possession of this 1 katha 10 lectures of land, or not. List accordingly, showing at the top of the list on 29th of August 2024.
If it is not inconvenient to your lordship, can it be on 30th or 31st May?
We have it on 27 then. He can get it.
27 is the next working day, because we have 4 days holiday.
29. 29. Nothing doing. On 29th August 2024, at the top of the list, showing it as parted. The personal appearance of the district commissioner is dispensed with.
Production list item number 1.
Yes, my lord.
Yes, what has happened?
Not serving the notice upon the petitioner, my lord. GMC authority is contemplating to demolish his shop. Notices has been.
Who has given?
My lord.
You are to vacate from where?
The allegation is regarding the illegal.
You are
construction of
hereby
the shop.
directed to discontinue the undertaking works of erection or erection re-erection of construction of unauthorized construction of the shop in front of the building of the man. This was given on 26. Then what happened?
Notice was issued on at place 31, first impute notice at 9/1.
Huh?
31.
Then what happened?
In response to that, the builder has submitted his reply, my lord, on 19/1 at place 34.
Document asking notice. Tilutoma ever Samar Kokoti proprietor so-and-so a letter has been received from Ashok Sharma and others regarding alleged illegal construction of the building. Hence, you are requested to submit a copy of the date tax receipt. No objection certificate approved plan. Then
Then, my lord, that note, after that reply, another notice was purportedly issued under section 337, 1 and 2 was issued at place 36.
33.
Place 36, Annex 7.
Then
My lord, pursuant to that, the builder has again submitted his reply at page 39. That the shop in question has already been sold 10 or 12 years back. And then my lord kindly see as page, there are 9 of my petition.
Then
Then on 20th, day before yesterday, the GMC enforcement branch, personnel from the enforcement branch has come for demolition of my shop without putting me on any notice. And immediately on next day, on 21, I have made a representation before the commissioner, the last page, my lord, in Annex 10.
So,
my
you-
lord, the notice under section
then a
337.
simple question is, what is the unauthorized construction?
It has to
Shop
be
in front of the building. Did you have a permission to construct a shop in front of the building? Where is it? Show me that.
builder can provide. my
I am
lord.
not concerned with that.
I am the owner of the shop, my lord.
You purchased it without this demolish.
No, my lord. Kindly see 37(1). For a
No,
moment, my lord. The notice has to be issued to the owner of the shop, my lord.
no,
The owner.
You are a tenant.
I am the owner.
Oh,
I
very
have
well.
purchased the shop.
So why did you purchase it? Did you see the permission? Did you see the permission?
Plan, my lord.
Yeah, show me that. Why haven't you enclosed that? That there is a permission for construction of a shop in front of it. Show me that. Matter ends. The sale deed is what?
Sale deed, lordship,
Sale deed is there.
page number, oh, my petition page, lordship has designated, no. Page
Sale deed is for not for any building, any shop.
only for land.
Kindly see the permission, my lord. Kindly see the permission. Page 27,
What permission?
the area. 4.86 Lacha.
No. First and foremost, no, mister, nothing, no, mister, nothing doing. If this is the deed of sale on which you are claiming right, where is the shop?
My lord, that is in the schedule, only the proportionate
Where is the shop mentioned in the deed of sale?
is in the permission.
You don't have any right.
Area is.
You are not the owner. You know, not the owner. Demolish it, demolish.
Well, I am the owner, my lord. Kindly
You are
see
not
what-
the, where is
it
the,
has been
no,
accessed.
no, mister. Where is your document of purchase?
That is the only sale deed, my lord. In the permission.
No, permission.
That is-
Mr. Counsel, permission would not do.
Will satisfy, my lord. Kindly see the tax paid receipt of the JMC that has been assessed as the holding. And it's the.
Where? Not the tax paid, where is the assessment register?
This is my lord, Annex 2, page 29. Page 29, my lord.
Ah.
It has been assessed as holding, my lord.
No. Where is the assessment register? This is only, no, you can very well get it from the certified copy. No.
My lord, kindly bear for a moment. The petitioner, the builder has specifically stated in his reply to the authorities
No,
that all the original
nothing-
documents related pertaining to the
nothing-
building, my lord. Kindly, for a moment,
Okay,
kindly, my lord. All the related documents has been handed over to the society of the.
First and foremost, you have no right of the shop.
What, my lord?
No right over the shop.
My lord, I have the right. I have
Show me the
purchased.
shop which have been sold to
My
you.
lord, it is, the schedule has been defectively
So,
drafted.
How
It
can
is
I
only
help
the
you?
proportionate share of the land has been mentioned, my lord.
no, be in
I
the
am
land.
occupying the
Happy.
shop. Kindly see
Be
my
happy in
trade
the
license,
land.
my lord. There's annexure 2. Kindly see my annexure 2, my lord.
Mr.
Trade
Counsel,
license.
better off.
My lord.
Mr. Jalan, better off. The Commissioner GMC may be more understanding than me.
Lord,
I
kindly see.
am not. only.
For a moment, my lord. Kindly
No.
see annexure 3. This is the trade license, my otherwise. Where I am carrying on the business? I am carrying on the business at the same site, my lord.
First of all, your ownership has to be seen. Where is your ownership? Unless you make it correct, how do I do it? Show me a document by which there is an approved plan for a shop. Where is the permission
The
for
land
construction
documents,
permission?
all the land documents.
You
pertaining
have
to
been
the
no, Mr.
approved section
Mr.
from the-
Jalan,
it
you
is
have
not
been
the society, not the society.
you have been kindly
I
see.
cannot get it from the society, my lord. Kindly see my reply, my lord. Kindly see the reply for a moment.
And what is this the permission for sale?
30.
No, page 25 and 27. What is this?
Land, only land.
Not land. In the, kindly see in the area.
Ah,
699, that is the square feet, my lord. 699 is the square feet
where? And for what purpose?
for a shop, my lord. That's
No, no.
It is not in there.
No. Read it properly. For
Intended land
residential
is
use only.
residential. Intended land is
Land
the
is
residential.
residential.
If the reports are called for, my lord, it is a semi-commercial building. Commercial come residential building
Demolish,
permission has
demolish.
been granted, my lord, only because the copy of the approved
Demolish,
plan is not
demolish.
in my hand, that
If you have
cannot be
not-
ground for.
If you have not demolished it
My
quickly,
lord,
quickly.
Sale deed was executed on 28/12/20
yes, that is
2020
3 years back, but
and
it was
2024.
put
They
in
have
the
not
year
rectified it.
2012. It was
Demolish,
put in the year
demolish.
2012, my lord.
Demolish.
My lord, kindly call for the records for a moment. If I do not have the
The
records, my
record-
lord,
the
just
record,
because I
Mr.
do not have the
Jalan,
record, I do not possess the
nothing
record,
doing.
which is are in the hands of the builder and the society, can I be penalized, my lord?
Yes, because you are not the owner.
I am the owner. That has to be established. My trade license is
Therefore,
fixed, my lord.
no,
My trade license,
no.
my holding
Trade
number
license is nothing. Trade license, you can just apply. You can sit out here in the
Kindly
corner.
my lord,
No, Mr.
I will
Jalan,
only
you
read
just,
only one line,
you
my
can
lord.
ask your friend out there to sit out there in the corner and ask for a trade license. He will immediately get it. Here only.
My
You
lord,
don't
only
need
for
to
a
go
moment,
anywhere.
337, one,
No.
only for a moment. May I read, I may be permitted on the decision, my lord will pass the decision.
Yes, what is this?
If any building is erected or re-erected in contravention of any development scheme mentioned under section so and so, or any building bylaws made under section 416, or without plans having been deposited, or notwithstanding the rejection of plans, or otherwise then in accordance with any requirements subject to the which the commissioner passed the plans, the commissioner may, without prejudice to his right of taking proceedings in a court of law for such contravention, by notice to the owner, either require him to pull down or remove the work. The word is I am only praying for that a proper notice may be served so that I can explain my position. The notices will issue to the builder, my lord. He has no interest. I will be prejudiced, my lord.
Who is Samarkanti Biswas?
Samarkanti Biswas is the builder, my lord.
But how do I show, but you have,
For a moment,
no, very well, but
satisfy my lord
no.
only on 27 itself.
27, okay, we'll have it on 27.
Till then, my lord.
No,
my
till
lord,
then business.
I
You-
may be imposed
not-
fine. If I fail to substantiate my ownership, I may be imposed fine, my lord. I'm making a statement on record.
Fine for what?
If I'm misleading, if I'm making any misleading statement.
No, from these documents, there is
My
nothing
lord,
that you are
because
owner.
day before yesterday, they have came in the evening. Yesterday, I have made a representation before the commissioner, which is pending. Let my representation be considered.
You do one thing.
My
Go
representation be
and
considered.
say that we have filed a writ petition, it is there, and the court has fixed the matter on 27.
That I will
Don't
do, my
it.
lord. That my representation may be considered. With that, okay,
Absolutely
one line
no,
observation, my lord.
absolutely
Some
no,
protection, my lord.
no protection.
Not have pressed, my lord, that had I been in, not the rightful owner, my lord.
Hmm.
Only because the land documents are not in my hand, I may not be penalized, my lord. I will satisfy on 27. Till
As
then,
of
no
now,
corrective
Miss-
action.
Miss-
If within
Miss-
4 days, my lord,
No.
if the action is taken, only one line, that my present.
What do you want? Dismissal?
No, my lord.
Which one? I can only, the best order I can pass is list the matter on 27.
Much obliged.
List the matter on 27/8/2020.
I have received a WhatsApp, my lord, of the NOC. NOC is only for residents.
No, it is commercial. I will show.
I have
will
it.
show.
The matter on so Mr.
There are six
Mr.
of-
L.
then why
Bora,
only one of
the learned
individual?
counsel appearing
If
on
there is a
behalf of
commercial
the
building,
GMC
no license for
shall
commercial.
obtain instructions. I think that order is enough. You just tell them.
Okay.
You don't have a case.
I will.
এটা আছে নেই? এটা মুছন আছে। Bench 5 with this. Yes, Mr. Boni. If I remember correctly, what you submitted on the last occasion is that once an election proceeding starts, court can't interfere. One, NP Punasoy. Secondly, it can be only done by way of an election proceedings. Without there being an election proceedings being initiated on the basis of a document which was filed prior to but after the election proceedings were declared, one cannot set aside this. That's your submission. Eh, na kami kita ko na niso, nila pala pa yun. Cooperative society.
Lordship has the rules.
Ikaw naman ako, mura ko.
Rules of the-
Yes. Which rules?
Lordship, all the sections relating to the power of the register, I'm going through. First, I'll come to section 26(3) of the Act.
This belongs to whom? H.I. Chaudhary. Section?
Wait, first, I come to 26(3) of the Act.
363, yes.
The chief executive of every cooperative society within the closure as cooperative shall do a vote valid for the current financial year. The list shall be affixed on the notice board of the head office of the cooperative society for information of all members, and any member not satisfied with specific instances of inclusion or non-inclusion of members in the list may appeal to the board within 10 days. This is one part I'm challenging, that they did not put such kinds of notice. This man, the ex-chairman was controlling over the board. The 1-1 committee was nothing.
Madam, kindly come back to the point which is being raised. I don't want beating around the bush.
The power of the
Kindly
register.
come back to the point. Here, the point which have been urged is, although I am otherwise against the petitioner, but the point which he has urged is, look, the election process have been initiated by issuance of a notification by the register of Eastern Register of Cooperative Society. It can be challenged. Anything out there as regards voters list not being proper, anything has to be challenged by challenging the election proceedings. And that is mandated in terms with section 27, rule 27 of the rules. If you don't do that, you cannot set aside my election. You may say whatever may be, but you cannot set aside this election by the register. Here is a case where the register had taken into account some document which came into existence even prior to the notification of the election process. Come back to this point.
Lordship will come to the rules.
Show me the registers have the supervening power that irrespective of these election rules, the Act gives them the power to decide this irrespective of anything.
Yes, in the rules, Lordship, at rule 23.
Election,
Yes, rules.
yes.
The election authority may order for re-election after declaring the election null and void for sufficient reasons, and after inquiry, if he is convinced that the process of election was grossly vitiated or violated contrary to the laws at any stage of the electoral process. At any stage of the electoral process.
So when do you declare an election to be void?
he has ample power. If he finds out that there was some mistake in the electoral rolls, in the preparation of the thing, he can do this.
Can be so. That power, if it is given, then they may do at any point of time.
Yes, at any stage, it is written. in the-
No, you can't give this power to the registrar in such a manner. It will have a far-reaching consequences what you are submitting. Because if we say that the registrar can do at any point of time, maybe after 4 years, he may say, look here, this election which was held was wrongly done, we do it.
Then let them
Can it
tell
be
me,
done?
let them
No.
go with this.
No, this can't be done. This can be re-election would be only permissible when the election may for re-election may order for after declaring the election null and void.
Yes.
The declaration of the null and void can only happen in terms with this what do you call the redressal of dispute. Then only it can happen.
It was the redressal of dispute was
Any
there.
dispute
The registrar
relating to
had-
the year has to be valid. It may make an inquiry upon the dispute on the basis of and pass necessary orders.
Yes.
So then only this can be done.
Yes.
Without taking reference to 27, how can he go to 23?
No, it is not a question of 27 now. It is my representation was prior to the election.
So,
I'm not on 27. It cannot be because I say that I'm also a member of the committee. I'm also a member of the society. Without we being informed of the election, we never have any information. We file representation. Even some other people also filed information. Lordship, may kindly come to my.
no, why didn't you file a writ petition? You have no information of the election. The election is being notified by them. They notify it.
They notified.
Then-
Here, my.
Did you
they-
file a writ petition challenging that they did not notify?
No, but
No, that is it. How can you say that? You can't say that.
but the registrar has the power to look into it. When he found that anomalies in the code,
Understood. If the election dispute is to be taken by the rules, there's a rules being done. Can the registrar act beyond that? You will have far-reaching
then
consequences.
there's the order of this honorable court, Justice Honorable Justice Ujjal Bhuya. He says about the formation of tribunal. Let them go there if the registrar is not.
Why they will go? They are not against that
I
election proceedings.
They want it to be, but when the whole
You
thing.
have to go. You should have gone. And Justice Bhuya's order to this would be to that effect that without an election tribunal, you cannot.
Cannot.
Now they have an election tribunal by these
I
rules.
have to go. But here, let us come to the merit of the case first. Now, Lordship, when apparent on the face of the record, the whole election is vitiated, and then there was no correction done. First round of litigation to come to before this court, violation of natural justice. Lordship sends back it to the registrar. Registrars may, with that direction, the registrar should call both the parties. They should sit, then hearing will be done. After that hearing, this was set aside, this election. Again, they come before the court, second term litigation,
Them they can count 100
100
times
times.
or
Yes,
whatever
yes,
may be. The
yes.
question is, how do you address the point which he has raised? That is the question I am
I'm
before.
also saying if the,
That can the register, without there being a challenge to the election, hold that the election is bad?
that
That's
is,
the question. Can it?
he cannot.
There's no other second thing.
But apparently,
Unless Mr. S.K. Talukdar helps you out.
With
What do you say on this?
Let this view also.
No.
This will also.
no,
Then
Lordship,
let us hear.
there's another one.
Yeah.
In the list what they submit, the elected members, although it is not a pleaded one, there is a mandatory provision. It's an article in the constitution provision that the board has to have 2 women. Here only 1 woman. That's a mandatory provision. Only apparent of that also is one part. That is a very important issue.
Mm.
Lordship will come to their petition. What they next did. How can they go away to the mandatory provision of the constitution? Lordship will come Annexure D, page 35 onwards. Lordship will come? 34. Category BOD, stronger. 36, weaker. SC, 1 SC has to be there, 1 SC is there. But in case of women, Lordship will come, there is a 2 reserved for a woman. But
Madam, is that the ground on which his election has been done? That is,
That I-
madam,
but the court will also.
you give whatever you say on this point, it just reminds me of this 1952 judgment I go back to that another 70 years down the line.
But the rule, Lordship, it gives ample, it can set aside, the registrar has the power to set aside
How? If
elections.
it is being done, tomorrow you may be on the other side. Just think about it. If the register can do it beyond the rules, you are giving too much of a power to an officer.
I understand, that is what
Let us hear what the officer has to say. What do you have to say? Otherwise, I'm in your favor. But the law point is troubling this court.
But I'm asking him whether he will stand, my lord, or he will take his seat.
He keeps on standing only. So that immediately if something goes, as of now, nothing is going, so he's not saying anything. But the moment something goes, he need not wait, just stand up. Tell me.
Mail, please, Lord. My lord, in fact, here, the point, my lord, raised by my learned friend is a valid point. But, my lord, in fact, that would again beg a question whether or not, my lord, the registrar has a power under the scheme, my lord, to pass the impugn order. And if your lordship goes through the impugn order, your lordship will find essentially, my lord, it's an order disapproving the AGM, my lord. If I take your lordship's, my lord, to the relevant part of the order at page 102. Last part, my lord, 21/9/23. On perusal of the attendance sheet of the AGM held on 18/3/23, it is found that many shareholders have signed the attendance sheet twice, and signatures also have been found against the share number of dead voters. As per section 29 of Assam Cooperative Societies Act 2007, General Assembly of a cooperative society shall consist of all the members of such cooperative society who are eligible to vote at general meeting of the society. Therefore, it can be ascertained that the voter list of Meherpur Krishnapur Cooperative Society is full of anomalies. Hence, this is important, my lord. The AGM election of Meherpur Krishnapur Society Limited, held on 18/3/2023, has been held in violation of the Assam Cooperative Societies Act 2007. Hence, the earlier order disapproving the AGM.
Wait. Just let us. Can an AGM be put to challenge by the authority, set aside by the authority, without a challenge being made to the AGM?
Correct, my lord. In fact, the provision is section 45. 45 requires the proceedings of each and every AGM, my lord, would be approved or ratified by the registrar.
You don't ratify, it's a different thing.
Approved.
But can you say that to that effect?
Exactly, my lord. If your lordship comes to 45, I'm reading it out, my lord.
Why the registrar at the first instance, at the time when it was filed on 14/8, she filed some communication. There was a communication filed
Yes.
prior to that. Why at the first point, the registrar did not stop there? Why did it notify? They may have thought it, but why did you notify in spite of that? And now you are saying that we are cancelling. Every cooperative society shall record its minute so-and-so, so-and-so, so-and-so of the general meeting, general meeting of the so-and-so and so of the cooperative society shall be sent to the registrar within from the day of the completion. So shall give his approval on the resolution within 15 days of it. If no approval is received within it, the sale shall be been approved. And when did you send this thing for sending it?
Exactly, my lord, that I'm coming. So therefore, my lord, here it says that within 15 days, it has to be approved. In absence of approval thereof,
There is a
there is a
deem.
deem approval.
Ah.
Now, my lord, the AGM was held on, my lord, 18/4. 18/3, my lord.
18/3.
Assuming, my lord, that on the next date, 19/3, assuming that the registrar had received the proceedings, my lord. So therefore, my lord, 15 days will expire only on 3rd of April. By this time, my lord, the registrar was in session of the matter on that your lordship will come.
No, but did you reject it?
Yes, my lord. Yes,
Where?
absolutely, my lord.
When did you reject it?
Yes.
that your lordship will come to. I'm coming to that, my lord. Page. Page 84, my lord. This is, my lord, if your lordship comes to 84, the type copy,
Mm.
your lordship will see by this time on 28/3/2023, before expiry of the term, the register was in session of the matter.
Mm.
And accordingly, my lord, he says that the AGM, my lord, is liable to be disapproved under section 45 of the Act.
Mm.
This was put to challenge in the earlier round of litigation, my lord. Then, my lord, your lordship says that since the affected party
Mm.
was not heard,
Mm.
so registrar will take a fresh call, my lord.
Mm.
And subsequently, my lord, the present impugn order comes into play, my lord.
Then let us see this order
Yes.
at page 87. Is this a case of seeking an approval? Page 87.
Page 87, no, my lord.
Then-
Page 87, no.
How do you import 45?
Here, my lord, no. But it is, yes, yeah. Yes, my lord. By the time AGM has been held, absolutely, my lord. Absolutely. AGM has been held already.
AGM has been held, it's okay.
Yes, it's a case of.
But what you have done is this was AGM was held and there was a complaint. You have exercised a power on the basis of a document prior to the AGM.
Correct.
Okay.
Correct.
But not on the consideration, you did not exercise 45.
Understood, my lord. My respectful submission is the power under 45 is independent of Rule 27. Power under 45 is a supervisory power. My lord, if a register have a material anterior to the AGM election, my lord, which goes to show.
The power under 45 cannot be said to be a supervisory power. No. It is only a power by which you are to grant an approval.
My lord, in fact, what my
As that
respectful
power is being given to the effect that whatever is election is being held, the regime can do it. Because if you just say out here, this was done on 3rd, it's okay. But this was on a consideration of an application filed prior to the AGM.
Correct, my lord. What I'm trying to say, my lord, under 45, my lord, the power is given for approval. My lord, the power also rests with the register to disapprove the same, my lord. Because register cannot approve without application of his mind. Otherwise, he will be, my lord, reduced to a post office, my lord. So therefore, there was a material before him while considering, my lord, the AGM, whether to approve or not to approve. My lord, that material may be anterior to the AGM election, my lord. But ipso facto, per se, my lord, that will not vitiate, my lord, the order passed by the register under section 45. This is a material, my lord. And 45 has to be read with section 3, my lord, which says, my lord, the register is the, my lord, supervisor of the entire, my lord, the functions of the society. And is exercising a supervisory power under section 45. And being a, my lord, power under the Act, my lord, it is not subservient to Rule 27. This is my respectful submission, my lord. This is an independent power of Rule 27. He can exercise, my lord, pursuant to the AGM election. And this, my lord, he has exercised. So therefore, on the count itself, my lord, per se, it cannot be said that on that day, the register did not have the jurisdiction, my lord, because the complaint was not filed within 3 days from the date of AGM election, my lord. that argument in my respectful submission may not be correct. That will be amounting to take away the power of the
But if
registrar
the
under section
register-
45.
If the register
My lord.
does not express in its mind that it is in exercising its powers under 45,
I'm sorry, my lord.
can we just imply that he was exercising 45 when he categorically mentioned that I am only exercising the power on the basis of a communication being issued by him, a complaint being received?
My lord, may I put it in this way? The power under 45 cannot be exercised, my lord. It can be exercised only after, my lord, the proceedings is sent to him. He can say that the proceedings is disapproved. And that is, my lord, he has done in the present case. So
No.
at any point of time, he cannot exercise that power.
He doesn't seem to have done it on that basis. The AGM was held on air and it is found that many shareholders have signed the attendance sheet so-and-so and have found that shareholder so-and-so, as per so-and-so, general of the corporation shall consist of all members of the, therefore it can be ascertained that the voters list of so-and-so is full of anomalies. Hence AGM of so-and-so was held on demand has been in violation of the so-and-so and is likely liable to be disapproved under 45. So this is the power under 45
My lord, correct.
being
He has
exercised.
to, my lord, see
Yes.
whether the, my lord, bylaws, the scheme, my lord, has been followed or not.
Hmm.
So essentially, my lord, the argument is,
Hmm.
my lord, the register is without jurisdiction
Hmm.
to pass the order, impugn order,
Hmm.
because that was not done pursuant to an application within 3 days from the date of election. So if that, my lord, argument is, my lord, accepted and the power under 45 is negated, my lord, then the entire scheme would be defeated. Because, my lord, the supervisory power of the register would be amounting to take away, my lord. That cannot be, my lord. That will defeat, my lord, the very scheme of the act. He has been put at the helm of the affairs, my lord, to see whether the bylaws, the scheme, my lord, has been followed or not. And irrespective of, my lord, a wrong citation of the provision, that will not invalidate, my lord, if your lordship finds that the source of power is available under the scheme. That your lordship is aware, Sangeeta Theatre, my lord, 2003 SCC.
So you mean to say it is a case where it is not a cancellation or not setting aside an election, but it is a disapproval of the meeting.
Exactly, my lord, disapproval of the AGM. And in fact, in the AGM,
And for that, you don't require a challenge to be made to the election.
no, my lord, no. Because that AGM, it contains, my lord, the agenda of election. Once the AGM is disapproved, is a consequence, my lord, the election goes. And if your lordship sees the notice as well as the proceedings of the AGM, election, my lord, is a part of the agenda.
That I know.
Yes, my lord. So therefore, as a consequence, the election will go, my lord.
Or in other words, the election, the AGM, which requires to be approved.
My lord.
It is a statutory mandate that the election AGM is to be approved.
Absolutely, my lord. It's a mandatory requirement.
Either it may be approved in writing or it might be impliedly approved.
Absolutely. It must be deemed
But
approval.
If applying 21 of the General Clauses Act, if a power is given to approve, it is the power of disapprove is
Absolutely,
also.
my lord. And here is not a case that the 15 days, my lord, expired, having expired, there was a deemed approval. That is also not the case, my lord. Because before expiry of the 15 days, the register was in session of the matter. Therefore, there was no approval, neither approval nor deemed approval.
And it was having been done on 3rd of April,
My lord.
which was set aside only on 19/7/2023. And thereupon this court gave him the power.
My lord. Correct. So essentially, my lord, my respectful submission.
What happened during this period from 19/7 till this passing of the impugn order?
Perhaps one man was running, my lord. One man committee was running. Still running, no?
Still running.
Still running.
Why so long?
Exactly, my lord. It should be within 90 days, my lord. But due to, my lord, the proceedings, my lord.
Yes, Mr. Monique.
He has raised a very valid and pertinent point that 45 and Rule 27 I would address it this way. Prior to a particular date of in the year 2019, 27 was not born. Rule 27 came in with the rules of 2019. Prior to that, the interpretation we sought to give or the construction my lord would put would have the power of the registrar who at the helm of the affairs. The 45 is wide enough to look everywhere. AGM without election, AGM with election. This power was pitted against the power under 111. Meaning thereby, if I'm trying to persuade my lord,
I think you are going to the question that this court have already held it, that this power could not be
No, but
exercised unless you have the election rules.
once that point came, that is the point when his argument would fall, with all respect. Prior to 2019 rules, maybe exercise under 45 or 111. But once it was declared by a court of law under Article 226, the constitutional provision that a registrar, being the man who runs the show, cannot in any way take a call if anything goes wrong. It has to go to election authority. Short of that, till then, the district
No,
justice, etc.
Understood. For the purpose of election authority, it's okay.
I'm even
This is
addressing
not there.
absolutely.
But but has the provision of 65,
when
45 been set aside?
When a man holding office would exercise power, it would have two things: on what he is acting and what he is considering. He was acting on the basis of a complaint, which was lodged when the election was notified. The election program was notified. The notification brings in Rule 27. Therefore, the departure of Section 45. That's my humble respect, my submission below. If he was not acting on the complaint and in a routine procedure, he takes a call. In a different case, maybe I would have said he might be correct to that extent. Of course, arguments both sides. But once the election program is notified, then the election rules come into play. 45 now gives way to Rule 27. And therefore, if the registrar is to exercise his power, it has to be by way of petition under 27. Or there may be countermanding, or there may be re-election. That's a different issue. But 27. This is how I differentiate 27 and 45. I place it to your lordship.
Huh?
That is how I place the matter, my lord. 45 and 27.
Done.
And this was uncontested election.
Therefore, that is the most reason why I'm saying.
Correct.
If it is an uncontested election, maybe, but the question is the power to approve still remains.
Power to approve remains. It will have two connotations. Power to approve in a normal AGM.
Did the judgment of Justice Bhuya say that you may disapprove the AGM, but still the election out there is required to be set aside by in accordance with the power cannot be exercised under 45.
Different context.
Question never
cropped in. But I would like to address on this point, my lord, that so far as the power to approve is concerned, if it is detached from the election in a given case, normally AGM would happen, 45 comes into play. But elections notified, then 27 has to come into play to set aside the election. Election cannot be set aside without a challenge or without invoking Rule 27. There is no challenge to election even till date.
But if the approval is not given,
the approval is
so why here the order which have been challenged out here is not setting aside the election. What is being challenged out here is that AGM is disapproved.
Correct. What I am trying to...
You are not challenging the aspect as regards the election. You are saying challenging an order where the AGM has been disapproved. Can you remember?
Which stems out from a complaint when the election was notified. After the election was notified. That does not bring in the jurisdiction of 45, rather 27. That's my submission.
Hello. list the matter on 29th of August 2024 at the top of the list and deliver the judgment in your presence. Take up other matters. The hearing being almost complete, list the matter on 29th of August 2024 at top of the list.
Actions being undertaken within the prohibited 100 meters and restricted 200 meters areas around the centrally protected monuments in Nilachal Hills. Actions for unauthorized construction within 100 to 100 meters. Please inform the actions that the Archaeological Survey of India can take for buildings already constructed without the proper approvals within the 100 meters and 200 meters restricted area of the centrally protected monuments in Nilachal Hills. List of approvals for construction. Existing buildings in protected and regulated areas. Please provide list of all approvals that have been sought for construction with the regulated 200 meters around the centrally protected monuments. 5. 6 is existing buildings in protected and regulated area. Provide any buildings which currently exist within the 100 meters prohibited and the 200 meters restricted area. So section 20 capital A and 20 capital B, your lordships will recall, which is that 100 meters is strict prohibition, no construction. 200 meters is when? Now, their queries are 512. Your lordship has been. So your last query, Milas, at page 512. Your lordship has seen 512 minutes. Reply to queries. The last query, in fact, it says that they had conducted a survey according to the site plan prepared in 2017 and 2018. There are a total of 17 buildings within prohibited area and 227 buildings within the regulated area around protected monuments in Nilachal Hill. So it is not that it doesn't have jurisdiction; it does. And the 100 meters, if it applies, then no construction can take place with it. If your lordship goes back to query 1, the 400 Bhairavi, which is there, 200, 800 dancing, 200, 7 and 8 at page 509, and 7 and 8 pillars are squarely within the complex.
Understood, but you see, the ASI also says out there that they will take due action if any construction is started.
Yes. I follow what follow, but then there was a requirement therefore to take clearance from them, because today your lordship comes to page 270. 270, the chief secretary on affidavit has said it is not a protected monument, therefore they don't need to take provision. That is what he has said. 270 of the writ petition. Starts at page 265 and 270. Paragraph 4 minutes, 270.
Is the affidavit filed by?
Affidavit filed by the chief secretary in the PIL, which they have annexed as part of the affidavit file here. Starts at page 265. Your lordship has 265 is the affidavit beginning. At page 270. Paragraph 4. That with regard to the statements in paragraph number 2 of the petition, the deponent respectfully states that the Ma Kamakya temple is not an archaeological site as per the provisions of law, and the project undertaken by the respondent has nothing to do with the puja paddhati of the Ma Kamakya temple. So they have proceeded on that basis, and in fact, that is why I had also requested in the lordships in the orders of 22nd of May and 19th of June had said that the respondent number 3 may file an affidavit, so if so advised, but they have not. That is why the ASI, today, this strangely enough, in a pending matter, ASI has not chosen to file that response. But the queries to which they have responded on RTI shows that there is jurisdiction over there. They themselves says the 100 meters and 200 meters applies. 19th of June minutes and 22nd of May is your
You are appearing for response number 3.
Yes.
Why affidavit not filed? Let us first consider my question which I have
Your
raised.
Lordship's order, Malad, 5th and 6th of August, Malad. Your Lordship has sought directions from the respondent number 10 as to whether the hydrological and geotechnical, Malad. 5th August, Lordship is very clear that way.
Yes, respond number 10. What is your stand?
My lord, it starts from running case number, my lord, 24.
If you can come here.
If I may read it, my lord, from paragraph 3 onwards, my lord, it is short affidavit, my lord. Paragraph 3, my lord, we have stated, my lord, that the Public Works Department of the Government of Assam has awarded Larsen and Toubro Limited, that is respondent number 10, the contract for Ma Kamakya Temple Access Corridor, Guwahati, Assam, on engineering, procurement and construction EPC mode projects situated at Guwahati. Then, my lord, at paragraph 4, we have stated that in respect of the hydrological and geophysical survey that would assess the impact on water resources and aquifers of the Ma Kamakya temple, the government of Assam in the Public Works Department decided to engage a separate consultant for the EPC contractor, that is L&T, for technical consultancy services of hydrological and geophysical investigation, which is an important pre-construction technical aspect to ensure proper implementation of the project. Accordingly, White communication dated 25/6/2024, the Chief Engineer of Public Works Department called for expression of interest from the respondent number 10 for this separate scope of work. That expression of interest, Lordship, will find at Annexure A to this affidavit, my lord, at page 483. Page 483, Annexure A. If I may read it, my lord, this is an, my lord, communication expression of interest, my lord, from the Special Chief Engineer. Subject: engagement of consultant for technical consultancy services for hydrological and geophysical investigation for the project Ma Kamakya Temple Access Corridor at Guwahati, Assam. Dear sir, pursuant to the approval of PWD Department, Government of Assam had letter number 10/6 so to engage a consultant for technical consultancy services of hydrological and geophysical investigations, which is an important pre-construction technical aspect to ensure proper implementation of the project Ma Kamakya Temple Corridor. You are hereby requested to submit an expression of interest at the earliest, clearly mentioning your expression to carry out hydrological and geophysical investigation for the said project as a technical consultant at the government approved price of rupees so and so, inclusive of all expenses and taxes. As applicable with the following criteria, the conditions were laid down here, my lord. Number 1, the hydrological and geophysical investigations of the said project are to be carried out by you or your associate consultant as per your proposal. All the hydrological and geophysical investigations are to be carried out as per technical assistance and recommendations of Indian Institute of Technology, Guwahati, as per the MOU signed between IITG and PWD. Necessary vetting and certificates, etc., are to be obtained from Indian Institute of Technology, Guwahati, as per MOU. The payment of remuneration to IITG as per government approval file number dated 10/6/2024 for their technical assistance recommendation.
Mr. Potujari, tell me one thing. You were only asked on 24, 25-4, 25-6
Yes,
for the first time.
yes.
You were asked. Then why did this Parkson Overseas Private Limited prepare this in the month of April 2024?
No, because a discussion had taken place with IITZ, whereby in the discussion, the IITZ itself has recommended, my lord, suggested names of 3 agencies. That I have spelled it out at paragraph 6.
If IITG has done it,
Yes,
spelled it,
yes.
then why IITG has questioned, asked for the credential of this person?
No, IITZ has not questioned that.
Yes, you see that, if I remember correctly. Kindly see the affidavit earlier, the documents which have been produced before this court.
Part of this affidavit
No,
also.
no, kindly see this. It was filed on the last occasion. Where is that? By the response? Yes, here. Kindly see here. Page 400 and yes, here.
Lordship is referring to that observations made by the IIT, that finer investigations has to be done.
No, no, no. It says categorically, if I remember correctly, person this was given. Here, page 458, serial number 6.
Page 458.
Why did the IITZ ask about the histories where was involved if they have recommended them?
Lordship is referring to page 458.
Serial number 6.
Serial number 6, details of notable case histories where Person Overseas Private Limited was involved in groundwater flow and spring investigation of hilly regions shall be provided. Now, this is the crux of the issue. Here is the catch. Now, Lordship will kindly see. Let me read the whole affidavit, my lord. Person has not yet been, my lord, finalized. Person, they had submitted the quotation. We have brought everything on record. How the quotation was submitted by person, but person by itself has not been finalized. Therefore, IITG has, my lord, recommended 3 agencies that I have categorically spelled at paragraph 6 of my affidavit. Lordship, kindly see paragraph 6 of my affidavit. The unsigned deponent begs to state that during discussion, IITG submitted the names of 3 consultancy agencies, namely number 1, Person Overseas Private Limited, number 2, CSIR National Geophysical Research Institute, which is a government agency, my lord, and number 3, BPC Consultant India Private Limited, for conducting studies, and that 1 agency may be selected for undertaking the study. This we have categorically spelled out in our affidavit on oath, my lord.
So therefore, this is an additional contract.
Yes, this is the additional contract.
Which was not a part of the original one.
Original one, but the foundation was available in the original one. Therefore, we have quoted in our affidavit, my lord, the part of the brief description of activities. Lordship may kindly come to para 11. Para 11 of my affidavit. This is a part of the NIT documents.
Yeah.
This lordship has on several occasions gone through it, my lord. Para 11. Unsigned deponent beg to state that the original scope of work and the activities involved in the contract agreement consists of various stages of planning, which is quoted as follows. Quote, brief description of activities, survey, investigation, including soil investigation. Foundation is there already, my lord. And other related works and services, obtaining all statutory local body approvals, pre and post constructions through statutory bodies. The agency shall also take permission from fire department. All these are there, my lord. The lordship will also find all licensing and charges to be concerned authorities shall be paid by contractor for obtaining clearance. So the contractor has been given a leeway, my lord, under the contract. Now, by dint of this, my lord,
No,
communication,
no. A contract, if it is within the purview of the contract, then where is the question of payment of additional amount?
because, my lord, the agencies have to be deployed by the contractor.
Understood. If it was already there, isn't it was a turnkey project?
Yes.
So if it was a turnkey project, then in that case, where is the question of anything else?
Employer has decided, my lord, to,
Pay you more.
yes,
So, but as per you, it comes within the ambit of your scope of work.
yes.
Why that has not been spelled out?
So that has not been spelled out.
That
maybe
is the
not-
most
not-
important thing. Why haven't I have asked you a specific question that you are referring to other aspects of 25(6) and all. The question, therefore, my our order was very clear to the effect that initially this happened on the tender was issued on such and such date. Thereupon, there is it came into light that there is a requirement for which there is a agreement entered into by which the PWD shall provide all these data. On that day, Mr. Advocate General submitted that to the effect that, you see, PWD never does it. It is done through the PWD. PWD engages agencies. Therefore, my question is whether this engaging of an agency is separate from the contract. Maybe having an ancillary aspect is another aspect. But is it separate from the contract which have been awarded to you? My specific question to you on that day, which is recorded in the order, is specific. Why it is beating around the bush out there? You are not clear to that effect as to whether it is within the ambit of your contract.
Then,
If it is,
yes, we have made a statement. Then lordship may
because no, Mr. Borpuzari, kindly understand there are another aspect to the matter.
Hello.
If it is outside the contract, now let us see from your affidavit itself. There are 3 persons who have been suggested by the IRI. Why have you chosen him?
Because they have given the quotation.
Understood. Did you ask for the quotation from others?
No.
So therefore, why have you chosen him? You could have chosen the other government agency.
Government agency is there.
No.
Yes.
You have not chosen. Why? Therefore, if it is brought within the ambit of your, therefore my specific question is whether it is within the ambit of your scope of your work. That is the answer I wanted. If I get an answer to the matter, is over.
That answer is spelled out in paragraph 12. Kindly read, my lord. I'm reading it, my lord. Paragraph 12 at page 481 of my affidavit. Answering deponent begs to state that geotechnical investigation, including hydrological and geophysical investigation, having been understood as a specialist service, the Public Works Department later on, white communication dated so-and-so, has specifically approved the engagement of technical consultancy services for geological, hydrogeological and geophysical investigation and requested the respondent number 10 to submit an expression of interest. In response, the respondent number 10 has accepted and to undertake the responsibility to provide geological and geophysical investigation through a competent agency. In other words, the respondent number 10 has taken the responsibility to provide hydrogeological and geophysical investigation on behalf of the Public Works Department as a part of the contract agreement for a competent agency, as this is a specialized service.
This is
what meant
Lordship may also see paragraph 9. Paragraph 9, the answer to your lordship's query is there. Paragraph 9 of this affidavit.
Let me complete paragraph 12, my lord. There are a few more lines. It is also worth mentioning here that the respondent number 10 has agreed to undertake this exercise on behalf of Public Works Department with active support and involvement of IITG as the approving authority. Well, I sincerely submit, my lord, this will meet lordship's query.
So, which means the government of Assam is giving you extending the scope of the work thereby allowing you to go for a specialized.
Absolutely.
You engage whoever, ABCD, we are not concerned.
Absolutely, because this is the need of the hour.
No, that is the only question. If you engage whoever, so the responsibility is of the L&T,
Yes.
nothing to do with this person or anybody. To do.
Absolutely.
Yeah, yeah.
So, yes, it's in paragraph 9, my lord. That's specifically on a part. Yes, let me read 9 also. Then I'll come to my reply. That in view of the facts and circumstances narrated herein above, the answering deponent begs to state that although the geotechnical investigation, including hydrological and geophysical investigation, was not specifically a part of the EPC contract awarded to respondent number 10, but in view of the aforesaid communication dated 25/6/2024, issued by the Chief Engineer, PWD, Government of Assam, such investigations are now part of the EPC contract awarded to the respondent number 10. Therefore, it is most humbly stated that an expert agency out of the 3 agencies suggested by IIT Guwahati during discussion shall be formally engaged as a part of providing expertise, including within the scope of EPC contract awarded to the respondent number 10 for geotechnical and investigation, including hydrological and geophysical. So, geotechnical investigation was part of the original, including all survey. But now we are going a step further. And this exercise started from first week of April. So now, till now, person is not finalized. When person's credentials was submitted to IIT Guwahati on 18th of July, on 26th of July, they said that instead of 2D, there should be final resolutions. That comes under 3D. Therefore, now L&T is now trying to rope in the government agency, that is the third one, CSIR, Hyderabad. So till now, not a single agency is finalized. There are 3 agencies. One is person, the other one is CSIR, National Geophysical Research Institute, which is a government agency, and third is BPC Consultant India Private Limited. So when IIT Guwahati said that you should go for final resolution, then L&T is now compelled to get into act with the Geophysical Research Institute of Hyderabad. So they are expertise in that. So after getting all the credentials, then the IIT Guwahati in consultation with PWD as well as L&T will finalize one agency. That process is going on.
You have not till now finalized.
No, person is not finalized. Person was the first to get their credentials.
But you will be.
It is a fluid situation till now. But
may.
We are going to do hydrological test.
But you are going to issue a work order to them, additional work order.
To L&T.
L&T.
Not to other parties.
No. But does the government would have a say as to the choice?
Government have a say because government has, for this highly technical issue, government has a MOU with IIT Guwahati. So on behalf of Guwahati, PWD, IIT Guwahati will discuss with them because it is highly technical issue. So the expertise is with IIT Guwahati. So IIT Guwahati is totally controlling all the agencies which will be involved in this exercise. So ultimately, with IIT Guwahati's approval, the agency will be selected, and with the approval and constant monitoring, the investigation will be done. L&T is only concerned whether they will get some additional money or not. That we have clarified. That is not the purview of this petition now. And all this exercise started in the first week of April. If I may just point out to your lordship.
So their main concern is that whether hydrological test will be done or not, it will be done. Will it be done through a competent agency? It will be done through a competent agency under the monitoring and under the supervision of IIT Guwahati.
That's, I'm grateful to learned EG. At page 441, when was the earlier affidavit, the lordship, they had said that person has been engaged, it's been finalized. Page 441 minutes.
No, another thing is, where is that agreement with the
MOU.
IIT? MOU?
MOU, yes, lordship, it was in the earlier affidavit. 76. Article 1, scope of work. May I read it, lordship? Scope of work. The respective scope of work to be undertaken by IIT Guwahati under this agreement shall be as follows. This was signed on 25th day of June 2024.
Scope of work number 1, IIT Guwahati will provide technical advice based on the geotechnical investigation, including hydrogeological and geophysical investigations carried out by PWD Building Department, and accordingly, IIT Guwahati will submit a feasibility report to PWD Building Department. IIT Guwahati will examine the report and give the observations related to be identified subsurface features as stated in the report. IIT Guwahati will provide vetting to geotechnical investigations, foundation selection reports submitted by PWD Building Department for the new constructions relating to the project. Vetting of structural designs, drawings, work plan, execution methodology will be done by IIT Guwahati, which will be provided by PWD Building Department. Then PWD Building Department will also ensure that the execution of the work plan and execution methodology are followed as per vetted by IIT Guwahati. And the responsibility matrix is annexed at Annexure A. That lordship will find at 379.
But Mr. Advocate General, tell me only one thing. Is it within the scope of the IIT to choose which of the agency which the PWD will use as per this memorandum of understanding? It doesn't seem so.
From the communications.
No.
From the communication, two communications. 18 July's communication. We have placed it. Yes. First letter. Yes. Page 443, Lordship will kindly see. Ninth of July 2024 letter to the head of the Department of Civil Engineering, IIT Guwahati, regarding project Ma Kamakhya Temple Access Corridor. MOU dated so and so references. These are the meetings. The first MOU 25th April. This is 25th of June actually. Then meeting held on 8/7/2024 at IIT Guwahati with contractor L&T Constructions, Consultant Design Associate and concerned officials of PWD. Then later received from L&T, white later dated 9/7/2024. With reference to the subject cited above, a meeting was held in your esteemed institute regarding survey of hydrogeological and geophysical investigation of the above mentioned project, wherein as specialized consultant person overseas had presented technical proposal for conducting the said investigation. In this regard, I have the honor to submit herewith the proposal received from contractor L&T Constructions for your valuable suggestions. This is for favor of a kind information and necessary action. So the proposal which was received by L&T vis-a-vis PWD Lordship, it was submitted to IIT Guwahati. Now this is the response. Next page, 9 July, L&T submitted the person's proposal to us. This was by Sumanto Chatterjee, project manager for L&T. They submitted the proposal of person to the executive engineer, which we have forwarded it to IIT Guwahati. Now page 445 is the proposal of technical consultancy for hydrological and geophysical investigation for Ma Kamakhya, prepared by L&T, prepared for L&T, prepared by persons. So this proposal we have submitted to IIT Guwahati. That I am not reiterating now, last date I have done it. Then page 458. Now IIT Guwahati, on the basis of that proposal, got back to us. This is their response. To the 18 July 2024, to the executive engineer PWD regarding project. Subject, sir, the proposal submitted by persons has been reviewed and the following observations are on the proposal. So these are the opinions given by them. Here, they have given their opinion on every aspect. Like,
I have put the Advocate General as well as the the L&T. What is the army complex which person has done? Because against the reply to clause number 6 at page 462,
yes,
another project of somewhat similar nature was undertaken for an army complex.
Yes,
there is no detailing where earlier it has been mentioned that which campus, ISB campus in Hyderabad. How will even IIT-G will know which complex?
That is one aspect, Lordship, where they have done it. But the thing is that the procedure and the technology which they are going to use, that is where IIT is giving maximum emphasis.
No,
Till now, it is not finalized.
As from the reading of the memorandum of understanding, it is clear that the PWD will submit, give the inputs, the IIT will look into it and finalize as to whether or give
No,
suggestions.
IIT will also jointly survey.
Survey and finalize what
Yes,
it is.
yes.
I will take. But here is the question as to how the PWD will do it. You say that it will be done through a specialized through
Agency.
them, roping through them.
Yes.
Okay. Now, but the MOU does not in any manner show that the IIT is also responsible in looking into that
Sir,
aspect.
IIT, unless IIT vets and approves,
Mm.
not a single brick will be laid. That is in our affidavit, number one. And from the language of the MOU also, every construction activity
Mm.
will be done, will be started once the final approval is given by IIT Guwahati. Now, if the other side is not having trust on IIT Guwahati, then I have nothing to say.
No, that is okay. But only thing is that you
I
are
have
going
used
to
the word
choose. You are going to choose
Yes.
at the instructions of the IITG is not a part of the memorandum of understanding. That is what I'm saying.
But the subsequent action that this 18th proposal, then their response
Because
there.
as I could, when I heard Mr. Borpudari, I asked him, did you take any steps against the other two? He said no.
No. In the affidavit, it is given.
No, he has not.
It is given, Lordship.
Not against the other two.
Other
They have
two-
only
the
taken
other-
against.
These are now gradually it is a developing situation. These are developing stories now. June 25th, the MOU, 9th of July, the proposal came. 18th of July, the proposal was sent to IIT Guwahati. 25th July, IIT responded. Then third, there is subsequent development.
Auction, but not with the other two.
No, other two, now when the IIT said that go for 3D, go for higher resolution, what is given by person, that may not be purely foolproof. So you go for higher resolution. So now the next stage for L&T is to rope in CSIR. Paragraph 8. Page 477. It is an ongoing process, Lordship. It has not culminated till now. May I read it, Lordship? Paragraph 8. The answering deponent begs to state that IIT Guwahati has reviewed the proposal submitted by Persons Overseas Limited and reverted with their observations by communication dated 18th July, addressed to Public Works Department, Government of Assam, wherein IIT Guwahati made various observations. Thereafter, in pursuance of the aforesaid communications dated 18/7/2024, received from IIT Guwahati, the PWD wide communication dated 19/7/2024 requested the respondent number 10, that is L&T, to provide necessary information. Subsequently, respondent number 10 wide communication dated 26 July submitted necessary information to PWD for apprising IIT Guwahati. Thereafter, as per approval letter dated 3/8/2024, issued by IIT Guwahati, which has been communicated to the respondent number 10 by the PWD, Government of Assam, white letter dated 3/8/2024. The study is now to be done at a final resolution with identification of smaller features, additional investigation like mapping the path of subsurface precisely, protection of recharge zones, etc. These are the opinions given by IIT Guwahati. Accordingly, respondent number 10 has been advised by IIT Guwahati to initiate identification of other agencies like CSIR, National Geophysical Research Institution, and BPC as other options for such precise investigation. The process of finalizing the consultancy agency and the proposed studies is currently going, and the respondent number 10 is actively coordinating with IIT Guwahati and Public Works Department of Government of Assam to ensure timely completion of the investigation through a competent agency, which shall fulfill in-depth analysis on the basis of suggestions and requirement of IIT Guwahati for geotechnical investigation, including hydrogeological and geophysical investigation. So this clarifies everything, Lordship. The process is going on. And all the records are being annexed with the affidavit.
So as of now, person has not been finalized.
Not finalized. On record, Lordship.
Well, there's only one aspect I wish to bring to your lordship's attention. Because so far they've been going only on the flow of water and sand.
Before my learned friend said, it's the MOU, one of the recitals there.
376.
Whereas
376.
376B, the middle part. Let me read A and B. PWD is executing the project Ma Kamakya Temple Access Corridor at Guwahati,
Page.
page 376, MOU.
Yes.
Whereas the middle portion, PWD is executing the project to be referred as the client. IIT Guwahati has expressed their willingness and assured PWD that they are capable to undertake such a project and have requisite professional capability and requisite experience, resources, qualification to do a review and carrying out vetting of structural designs drawing of the project as per project requirement. So they have completely roped in here.
No, understood. But it would be better if while choosing who would
Yes,
be the
choosing
specific,
IIT.
let the IIT do it.
Now,
Because it is otherwise not reflected in the memorandum of understanding. Let the IIT have a say. Yes,
Now-
the IIT is doing it.
IIT is doing it.
Even if the affidavit of the respondent number 10 is also looked into, in spite of that person submitting all the proposal, the IIT has then also asked that why you are not taking from the CSI as well as the BPC.
They have not said that. They have what they have said, that we need higher resolutions.
No, here it says, no?
Now in the
No,
affidavit,
page 478. Accordingly, the respondent has been advised by IIT to
Yes.
initiate identify of other agencies like CSI
yes,
and
Lord.
BPC.
That is number one. And number two, why they are not very satisfied with person, because person says certain limitations. Their whole data research is based on 2D, two-dimensional. What they are saying that go for 3D, and person is not competent to provide 3D analysis. CSIR, as far as we have come to know during the discussion, CSIR have that technology, 3D. Maybe end of the day, there may be some better technology which may come out also, but everything will be done with the advice and involvement of IIT Guwahati. And where we are going to do, we are removing the existing constructions. And there only these things will come. No new area will be added, number one. And before starting the hydrological test, we have to remove everything, because hydrological test, if there is a normal pipeline in the home also, water supply, that will also have a reflection. So we have to remove everything. And the construction will be shallow construction. There will be no in-depth piling or etc. In fact, all the buildings which are already there, they will be removed and it will be flattened. It will be open area.
I have nothing to do.
Because end of the day,
For me, I have nothing to do with all this
Absolutely.
technical aspect. Only thing I have to see is that as to whether the IIT and the government is having a proper look as regards what the response number 10 is.
that for that, PWD and IIT Guwahati, they are the watchdog. Nothing will be done by L&T on their own. And PWD is having a direct MOU with IIT Guwahati, not L&T. L&T is a third party. That is an agency.
Has L&T agreed to the extra work?
Yes, they have agreed. They have agreed. It's hardly few lakhs of rupees, not a major amount. A very minuscule amount. So this is my humble submission, and this is precisely the question before the division bench also, this hydrological test, nothing else.
The only thing is later on, it should not be that the L&T comes up that, look here, we have done everything, we have given these are the, we are given these three, the IIT has given this, we have no responsibility what has happened.
In fact, for that, L&T will not be left. The direct first responsibility come to PWD. We have given them, but PWD is answerable to the people of Assam as well as to this honorable court. When we have chosen L&T, they have come to a proper process. There was other competitor also, very competent competitor. So they are already on board. And now additional work is to be done through a different agency, because they are also not competent to do hydrological test. So a third party has to be involved, and we cannot directly do it. Indirectly, it is a general contract. If you look at the contract terms and conditions, it is the responsibility that lies on them. And therefore, these three companies, as per the advice of IIT, they have roped in. And ultimately, Lordship, whoever will be doing the work, they will have to have a contract with us, additional contract, number one. And it has to be approved by
Additional
IIT.
contract is with them. They may have with whoever. with
Absolutely,
CSI.
Lordship, but that whoever, for that also we have a say. And we will base our say on the basis of the opinion of the IIT Guwahati. PWD will not say person is or CSI or the third one. We will not say A, B or C. Whoever IIT approves will go by their words. Because the petitioner is trying to promote another person in the petition.
It's
There-
okay.
So there are a lot of
Because
experts.
Survey of India is a statutory authority.
No.
Statutory.
They have given a name of a particular individual. The individual, I'm not
Other-
taking anybody's
They
name.
are not taking. Yeah,
So there are a lot of experts in the market.
Well,
Lot of experts.
We gave the opinion, that's why I'm very grateful because that's precisely what I wanted to bring to your lordship's attention. What Professor Sarada Sharma has said, in fact, incidentally, he's a very eminent civil engineer and he has no interest in this. He's 85 years old. Only reason is he's a devotee here. So the opinion that he furnished, he'll highlight a very important aspect your lordship will recall, the seismic aspect. It's a hypocenter. Well, today this is work in progress. Now, it was obvious today that the entire project was designed and the design consultancy awarded, design frozen, then the construction bid award, oblivious of the underground water springs. Because now that has obviously come to light. So now it is all post-facto rationalization, which is happening. And that too, because now the contractor is being given the mandate to choose the consultant to the, because who is getting already 400 crores and whatnot above that. Well, there's a fundamental conflict of interest. Even the MOU with IIT only says they will vet. It does not say that they will choose, as your lordship rightly pointed out. I'm grateful to my learner teaching us that if IIT is given the mandate, then probably obviously they will come with the right. But my only concern is this, that the opinion, because this is best left to express. I mean, the GSI is represented here, the Deputy Solicitor General. The Dr. Sarada Sharma has highlighted the aspect of not only the flow of the water spring, but the seismic aspect. And he says that it's a hypocenter, and that is an aspect which is any building activity in the northeast or anything has to take into account that part. So, what we see today, it's only geotechnical, geohydrological. Then we have Parson who did only rainwater harvesting. Now, because they were chosen by LNT. Then now they have to come up with someone else. So today, why cannot we have a reputed government agency? In fact, the earlier opinion that we had given of Dr. Sudhir Kumar, former National Institute of Hydrology, at page 248, he had suggested GSI. And I have shown how the Ajanta and Ilona case were.
They are trying to rope in the CSI.
No, that's not. Then if it has the experience, well and good, I'm not questioning.
National Geophysical Research. I think
If it has the competence, then certainly, because CSI is a national body. We cannot have any quarrel with that. Only part is that all these aspects should be considered. The seismic, because after all, Dr. Sarada Sharma of his own will, because the petitioner requested him furnished his opinion. He has no stake in this. He is not looking to make money. He has advised Chinese government on Karakoram Highway, India government on Bhuj, and various other governments, Indonesian government on the earthquake. He doesn't need an IIT project to sustain himself. Not at this age, he has 20 methods named after him internationally. He is doing it because he is a son of the soil and he has been a regular devotee, and that is what is sincere. So what my suggestion was that all these aspects, whether the seismic aspect, what is firstly the scope of the study? Because today, even the MOU with IIT does not mention protection of the sacred underground water spring. It only says geohydrological and geotechnical. What does geohydrological mean? There is no goal defined that you have to protect this sacred springs, not only in Kamakwa, but the entire international, the Kamakwa Hill complex. That has to be spelled out first. Then the IIT can mandate, but if they choose, whosoever they choose, I'm sure they will choose the right body. But then all these aspects have to be gone into. Today, because LNT, they engage Parson, because someone who did not have the competence, obviously not, then which is why we go on to the second stage. Only because of your lordship's monitoring. So otherwise, this wouldn't never happen. So my humble suggestion to your lordship is, as it fell from the learned AG, let the IIT have the mandate, then let them, let first the scope of work be decided, because the scope of work with MOU only says, it only relates to the contract, it does not relate to protection of underground water spring. And that is very important, because if that is not made the basis.
But all said and done, that is based on that only, because they have filed an affidavit to the effect that they have entered into the MOU with that design.
No. As it flows from the correspondence now, but what I'm saying is the mandate given to them, the scope of work has to be defined, and then
Let us further see what is happening, let me pass an order taking into account the affidavit which have been filed and what the Advocate General has submitted. Let's see what happens, because the ASI has also to come up with an affidavit, one. Second is as regards what is the further things are being taken up by the year as regards the finalization. Because the Advocate General says that although it is not specifically mentioned in the memorandum of understanding, but that is the mandate of the IIT. The IIT shall choose the specialists.
Lordship, this is not a part of the record. Lordship's consumption public. When I say first week of April, Lordship will just have, at that time MOU was not signed. So they are in complete knowledge of what is happening.
No, therefore, as he is saying, to that effect, let me formalize this thing and let us see what happens, how it is they are going ahead with the CS, the identification of that particular agency who is going to carry out. Once it is being done, then I think we can further proceed. As of now, let us see, it is still in as per what could be found out from the submission of the Advocate General, also seem that it is still at a very nascent stage. So let's see what happens, and also get a hold of the ASI to file. Where is the ASI? There, he's hiding behind everything. Yes.
But their instruction is very clear. And Lordship, ASI comes under Ministry of Culture. Before this project was finalized last year, I have annexed all the minutes of the central government when the Department of Culture was always present. And when 5th of January, the central government approved this project after considering the opinion of all the line departments. The Prime Minister laid the foundation stone in the month of February. So all the exercise has been done. Now ASI cannot say something else. I think he has that instruction on writings.
They have already said so in RTI response.
No, no.
I didn't.
Now my lawyer is trying to trivialize the whole issue. Who is denying that there are certain ISI monuments there in the whole hill? Nobody is denying that. The thing is that 100 meters and 200 meters, whether this project will have its location within 100 meters or 200, that is the core issue. My learned friends, clients should go and see how many buildings are already constructed there, how many hotels have come up there. Now, what we are going to do, without knowing the exact proposal, we are cleaning the whole commercial buildings there. All the commercial building will be removed from that place. And there will be easy access of the pilgrims to the temple. And it will be an open space. We are rather removing the constructions. The constructions were already there. And there are multi-story buildings, which we are going to demolish. And nobody is objecting because everybody is going to get good compensation, and it will be for the greater interest of the whole area, as well as for the state. Unless there is some vested interest, Lordship, there is no meaning of this petition. In fact, the core issue which is being urged now before this Honorable Court, same arguments we are making before the Honorable Division Bench also in the PIL. It is not a PIL here. On that ground only, Lordship, this petition may be dismissed. Now, all the grounds which they are taking, these are all material swap for a PIL.
No, Mr. Advocate General,
No, they are.
That cannot be a ground for dismissing of the petition. Because
They are-
you see,
because they are
there
not-
is a difference between a locus in a writ petition and a PIL. The
I fully
PIL
agree.
locus
I
is
have no
very, but
quarrel
here
with
it
with
is.
the law, but the issue is very clear. What is their main prayer? The main prayer is that it should become under Section 4 of the 1958 Act and 1959 rules. They are not urging that. Not a single time I have heard that submission from their side. They are only on the issue of hydrological test, which is the core issue before the division bench. They are writing something in the petition, the pleading is something different, and they are arguing is completely on a different
Mr.
footing.
Advocate General, He is not there before the division bench.
He is not there because he should have gone for it,
No,
because if he is so
He is
concerned
not
about.
there, but you are there in the division bench. Why are you not telling the division bench, look here?
The problem is that once we file the affidavit, they are taking adjournment day after day.
Who?
The other side,
No, why you are not asking the division
No, we do,
bench that
I
kindly do
thought-
one thing, take away
because
the
no,
matter from the clutches
when
of this
lordship is
court
putting
number
a specific,
70.
no, why we are not avoiding this court?
No, it's
Lordship has
not
a-
the question of avoiding.
Avoiding means,
Not this court. I'm not saying about this. So why should you
no,
have a
lordship
double
has
exercise?
certain specific queries. We do not want to hide anything from the public domain.
No, this
Lordship has-
it is all a part of the record. The division bench will look into it.
Is absolutely lordship, there is no doubt, but lordship had certain queries, so we have replied. But my original first submission was still open, that regarding the maintainability. The argument has not started yet on that point. So my humble submission is that if lordship is satisfied, these proceedings may be closed at this stage.
It's the most important. Now we are getting it.
Then we'll take the appropriate action.
Yes. Pursuant to the order, this court, by an order dated 6/8/2024, after taking note of the submissions made by the learned counsels for the parties, as well as the affidavit which was filed on July 23, 2024, as well as the additional affidavit filed on August 3, 2020, no, not August 3, another affidavit on 6th August 2024. Had put certain queries upon the respondent, the counsel appearing on behalf of the respondent number 10, as to whether the geotechnical investigation, including the hydrogeological and geophysical investigation, is a part of the EPC contract, so awarded to the respondent number 10, or whether the expert agency Person Overseas Private Limited is engaged separately or is a part of providing the expertise included within the scope of the EPC contract, so awarded to the respondent number 10. In that regard, this court directed the respondent number 10 to file an affidavit by bringing on record their stand. In pursuance thereto, an affidavit has been filed by the respondent number 10. From the perusal of the affidavit, it transpires that talks between the IITG, the respondent number 10, and the state of Assam were going on as regards employing a specialist for carrying out the geotechnical investigation, including the hydrogeological and geophysical investigation. During the discussion, the IITG, the concerned authority of the IITG had suggested the names of 3 consultancy agencies, namely, number 1, Person Overseas Private Limited, number 2, CSR, DES, National Geophysical Research Institute, bracket, which is a government agency, bracket close, and number 3, BPC Consultants India Private Limited, for conducting the studies, and also suggested that one of the 3 agencies may be selected for undertaking the study. It is also seen from the affidavit filed by the respondent number 10 that the Special Chief Engineer PWD-B has issued a communication to the respondent number 10 on 25/6/2024 on the aspect of engagement of consultant for technical consultancy services for hydrological and geophysical investigation for the project in question. It is also seen that the said communication so issued was pursuant to the approval of the PW bracket BNNH bracket close Department Government of Assam, letter dated 10/6/2024 to engage a consultant for technical consultancy services of hydrological and geophysical investigation, which was an important pre-construction technical aspect to ensure proper implementation of the project. And the respondent number 10 was asked to submit an expression of interest at the earliest, mentioning their expression to carry out the hydrological and geophysical investigation for the said project as a technical consultant at the government approved price of rupees 78,84,170, inclusive of all expenses and taxes such as IT/GST/LCES, etc. It is further seen from the said affidavit that the proposal submitted by Person Overseas Private Limited was submitted to the IITG through the Public Works Department, Government of Assam. In paragraph number 8 of the said affidavit, it is categorically stated that As per the approval letter dated 3/8/2024 issued by the IITG, the study is now to be done at a final resolution with identification of small features, additional investigations like mapping the path of subsurface, precisely, protection of recharge zones, etc. And accordingly, the respondent number 10 was advised by the IITG to initiate identification of other agencies like CSRIR, that's National Geophysical Research Institute, bracket, a government agency, and the BPC Consultant India Limited, Private Limited, as other options for such precise investigation. It has also been mentioned that the process of finalizing the consultancy agency and the proposed studies is currently ongoing, and the respondent number 10 is actively coordinating with the IITG and the Public Works Department of the Government of Assam to ensure timely completion of the investigation through a competent agency which shall fulfill the in-depth analysis on the basis of the suggestions and requirement of the IITG for geotechnical investigation, including hydrogeological and geophysical investigation. Paragraph 12 of the said order, of said affidavit, is very pertinent. In respect to the query raised by the order dated 6/8/2024. Wherein it has been mentioned that the geotechnical investigation, including hydrogeological and geophysical investigation, having been understood as a specialized service, the Public Works Department, by the communication dated 25/6/2024, has specifically approved the engagement of technical consultancy service for hydrogeological and geophysical investigation, and requested the respondent number 10 to submit an expression of interest. The respondent number 10 had accepted to undertake the responsibility to provide hydrogeological and geophysical investigation through a competent agency. Full stop. The relevant portion of the said paragraph being pertinent to the query raised on 6/8/2024 by this court is reproduced hereunder. Page 481 of Pabo. In other words, the respondent has taken the responsibility to provide so and so to the authority. Huh? This court have also heard the learned Advocate General, who submitted that the specialized agency for carrying out the geotechnical investigation, including the hydrogeological and geophysical investigation, would require a specialized agency, taking into account that the government of Assam are insisting the government of Assam, in liaison with the IITG, are insisting for having final resolutions with identification of small features. He submitted that a proposal submitted by the person overseas private limited was a proposal for providing to the, what is this to the?
Two-dimensional.
That I know. To the what? To the features, to the,
Technical analysis.
now you say it is to the, but the state of Assam wants the IIT saying
IIT said that
to the, what is that to the?
it is at page 459.
To the, what is that?
Serial number 16.
Ah.
The
He's
possibility of
providing to the, admitted that the person provided has 2D capabilities, whereas the IITG is insisting on 3D capabilities in view of the opinion
for
given
comprehensive
by the
subsurface village.
IITG on 18/7/2024. If I had submitted that the respondent number 10 now have been entrusted to get in to initiate identification of other agencies like the CSR, National Geophysical Research Institute, which is a government agency, as well as the BPC Consultant India Limited, Private Limited, as has been suggested by the IITG. He further submitted that the finalization of which specialized consultant services would be taken would be only undertaken with the consultation of the IITG.
Right.
First, this court have also taken note of the submission of Mr. R.K. Dev Chaudhary, the learned counsel who appears on behalf of the respondent number Union of India as well as the respondent number 3. He submitted the affidavit on behalf of the Archaeological Survey of India have been sent to Delhi for vetting and would be filed. The importance of the said affidavit is felt taking into account an additional affidavit being filed by the petitioner, bringing on record certain information provided under the RTI, under the Right to Information Act 2005. Taking into account the above, this matter when any information.
I have nothing to say.
No. When can we get some update?
From the, not from the state government. It is
No.
from the central government.
Central is okay. Yeah, from you, when are you going to finalize? Something has to happen, no?
Yes, the process is going on. It may take 6 months, it may take 1 month also. We cannot give anything because suppose CSR is not competent, then we have to explore third one, maybe fourth one, fifth one. So till now, 3 are in the zone of consideration. So we cannot give any word. It
So
will be
when
not
should I
right
fix?
actually.
When should I fix?
I will let it after 4 weeks,
We fix it on 1st of October?
Lordship.
Because nothing is now progressing.
1st of October is a Sunday.
1st of October is a Tuesday.
Yes, September, sorry. Okay. Yeah, Lordship.
1st of October, 2024.
Lordship may direct the central government to file the affidavit before that.
System. In the meantime, the Union of India as well as the ASI shall ensure that the affidavits are filed. System. The respondents shall provide any update as regards the identification of the specialized agency.
Deeply obvious.
Oh, that.
Well, it just needs to dispose of the matter. It was taken up yesterday. On the issue of demarcation.
এইখন হল কালি এখন ডিসপোজ অফ হৈ গৈছে কেছ তাৰ ভিতৰত ভৰাই দিব এইটোৰ নাম আছিল কি আছিল এপলো নে ব্ৰহ্মপুত্ৰ এইটো ডিসপোজ অফ হৈ গ'ল সেই কেছ দেখো Third, Mr. H.R. Emmett, the learned counsel appearing on behalf of the petitioner. Mr. N. Goswami appears on behalf of the respondent number. Respondent number 3. Mr. P. Hendick appears on behalf of the respondent number.
PNRD.
Appearing on behalf of the PNRD department. At the outset, it has been submitted by the learned counsel for the PNRD department that the instant writ petition, insofar as the grievance against the PNRD department have become infructuous, in view of the fact that the order dated 26/6/2019, which was for a period of 1 year, has already spent its force. The learned counsel appearing on behalf of the petitioner also agrees to the said submission. The second issue which is involved is that the petitioner herein have sought for demarcation by issuing a communication dated 28/8/2018. This court finds it very relevant to take note of that the government of Assam in the Revenue and Disaster Management Management Bracket Reforms Department had issued an office memorandum dated 21/12/2020 mandating the procedure as to how such an application seeking demarcation certificate can be applied. In that view of the matter, this court grants the liberty to the petitioners to apply in terms with the office memorandum dated 21/12/2020. And if such application is being filed, the respondent authorities, more particularly the respondent number 3, shall duly take appropriate steps in accordance as per the said memorandum.
3 and 6 minutes. Cycle officer.
Huh?
Cycle officer is 6 minutes.
6, you have to file to whom?
3 and
Before the circle officer. He's the respondent number 6. He's not appearing in the 6 going, huh? Wait, 7. 7. Not 6.
3 and 7.
Circle officer is 7. You are paying for 7 also. 3 and 7. Obliged post.
And now 4.
On last occasion, you all also.
What is the case about?
My lord, it relates to the non-payment of the two insurance coverage under Prime Minister Suraksha Bima Yojana and Pradhan Mantri Jivan Jyoti Bima Yojana, meant for the below poverty line people. And I have regularly paid the payment for the insurance policy. But when my husband died, I have applied for the return of the policy money. They said that there was no NOC, KYC. That's why you could not deduct money from your account. That's why it is lapsed.
What?
It is lapsed. We will not pay you.
How do you get the money? Under what policy? Show me.
Policy is the Pradhan Mantri Suraksha Bima Yojana and Pradhan Mantri Jivan Jyoti Bima Yojana. Two, one is 330 premium, one is 12 rupees premium.
And
So
you
my-
paid.
Yes,
And they are refusing on the basis of KYC.
KYC.
What is this?
So even last occasion, this honorable court has directed me to take instruction. Accordingly, I have taken
For
instruction
what?
regarding on why the KYC has been stopped against the petitioner, your lordship.
It's okay, but KYC can be filled up now also.
As per the provision of this two special scheme, your lordship, this scheme should be updated up to 2 years. They have not done within the 2 years. The petitioner has not done it. That is the instruction I have received.
Where? Anil Goswami was opened on demand as per. So there was no deduction thereafter made from his account.
No deduction. They said we could not deduct because there was no KYC. But it is automatically deductible. And my lord, interestingly,
How will
my account number has been changed by them, and without KYC, how my account number could be changed? I have specifically mentioned, my lord.
Yes, Mr. R. Goswami, you are there for?
For respondent number 5.
What is that?
One, we have 2 yojanas. One is Pradhan Mantri. One is for
Suraksha Bima Yojana.
Suraksha Bima Yojana and one is
And Pradhan Mantri Jivan Jyoti Bima Yojana.
Jivan. That is for SBI Life.
And
In
my
this case,
friend is
the
appearing for
premium
SBI.
has not been paid by the bank.
Huh?
In this case, the premium has not been paid by the bank to the insurance companies, for the insurance companies.
And
Licensed GIC.
was there any deduction from his account?
Earlier it was deducted.
When did you die?
When after the death of my husband, I went, they said there was no deduction. So that's why policy is lapsed.
The
But
policy, was there any deduction or not?
Earlier they've deducted.
Earlier it's okay, but KYC?
But they are
Because
saying
if
that
you
there
have
was
a-
no KYC.
no,
We
if
have
you-
no knowledge.
If you
There
have
was
a-
no notification,
No,
no
it can't
information
be
that
like that.
KYC is to be again updated.
What did the policy say?
It is there in the your lordship.
Policy is meant for the below poverty line people by the Prime Minister Office, my lord. These two schemes.
I mark as a flag A. That is the provision. Circular is this.
Then
Now it has been stopped, your lordship. All the debited accounts which have been operated have been stopped. Till the KYC has been lapsed. Within the 2 years, within 1 year, they have to upgrade it, but further 1 year has been extended. That period also, they have not done it. The petition has not done it. So automatically, KYC has been stopped and there is no any transaction. So ultimately, the policy has been left. The insurance, the issues. But the petitioner in
And
first.
if you don't pay to the policy, then what happens?
There is no coverage, insurance coverage without receipt of premium.
Insurance coverage, what happens?
Only insurance coverage instead only after receipt of premium. The premium did not come. The policy lost coverage.
These are yearly.
Yearly.
So,
So, my lord, your lordship is to see whether is there any fault on my part, because they have
fault too is there.
changed my policy account number. So unless there is a KYC, how account number could be changed? My account number is 1411 to 1431. It was done on 23/3/2017. My
From
husband died
14?
on my
14112?
1411. It was changed to 1431 by them on 23/3/2017. My husband died in the year 2017, and I have claimed 2018. They said no, we cannot pay you because there was your policy.
Change the account number.
Yes.
Yes, Lordship, that has been done.
How?
That is
How
the,
did you, of a dead person or dead or alive person who had no KYC, change the account number?
Your
And
Lordship,
how will they know? Did you inform them?
second paragraph it shows, Your Lordship, in the instruction,
What is it?
in the forwarding letter.
Huh?
First in the forwarding letter, Your Lordship, then again product of the say tiny 411. First page, Your Lordship.
But if a lapse account, can you change it?
Probably the corporate.
File your affidavit. You file this thing by way of an affidavit. Want it. And Mr. Biswas, find out.
My lord,
I
let
think
them produce
if I
the record
remember
that they have
correctly,
intimated
the
me. Let
Supreme
them
Court
produce.
have made certain observation of these type of matters where it should be granted. Our judgments. The B.N. Gogoi, the learned counsel appearing on behalf of the SBI,
Insurance.
SBI, I'm pardon.
submits that he has received the instructions. Taking into account the instructions, this court directs that the affidavit be filed on or before 23rd of September 2024. This the matter again on 26th of September.
Deep level.
Here's what is this? Affidavit. Why is this matter listed today? You have got your instruction.
I'm appealing for deputy commissioner, Lordship.
Who? Mr. Hendik.
Well, as far as this case is pertaining to non-payment of the balance, direction may be otherwise given to the commissioner to verify the pending amount, and whatever is he is entitled to may be released within a stipulated amount of 2 lakhs is remaining. The prayer is at
Going on.
page 10,
Plus 84.
How many people are there?
3.
What? There are a lot of people. I think you bring on record something. You can't say like this because why I'm saying it, there are you see who has filed this petition. 98 Hazirepara Gaon Panchayat job card Samodik Somtha.
umbrella body for all the job card holders.
So how many people they are asking for?
How many people?
262, my lord. Page 4, my lord.
So you have won this amount of 2 lakh 84,000,
Yes.
931. That's it.
It's 20, my lord. For the report of the engineer.
Let the BDO has to do the verification, but since he has not done since 2019, let the commissioner do it, the verification, and accordingly release the due amount within a period of.
It's the matter on 28/8/2022 at 2 p.m. Dispose it.
Please, your lordship. Matter is regarding compensation of rent and zirat.
Huh?
My lord, this is the order, a batch of petition, this was of by this American.
Non-payment of Zirat
And
and as well as also for adequate compensation in respect to right of use. You want the same order?
same one.
For you.
My lord, earlier order is filing application to the district court 30 days, instead of 45 days may be given.
You want 45 days? 45 days in district court Baksa? 42 days.
My lord, I'm for respond number 3 and 4, Assam 53 Grid Corporation. The name has not shown in the cause list. Today.
Okay, none appears for the respondents. He is appearing. Yes. If he is not appearing, I can't help.
My lord, there is a higher for him.
I disposed.
There is a higher, my lord. Higher for implementing party respondent number.
Not necessary, unnecessary. In view of that order, I will pass. With 42 days, district court Baksa.
7.
Why the matter is come up before a single bench?
Seeking compensation,
Huh?
lordship. This is for seeking compensation
For what?
for illegal detention, lordship.
Why?
Reason is that there was no reference against the petitioners and they were illegally, because reference was only against the husband of the petitioner number 1 and father of petitioner number 2 and 3.
What is the basis of asking 2 crores?
Lordship, right to education of the 2 children, lordship. So,
What?
two petitioners, petitioner number 2 and 3, lordship.
So why you are asking 2 crores? What is your basis? You are asking for a constitutional thought. Why?
Lordship, they were not being provided and they were being illegally detained. Article 21 was violated, lordship.
How many years?
9 years.
You were inside.
Inside, and no education was provided to these 2 children.
And then what happened?
Thereafter, since there was no reference, this honorable court, by order dated 1/2/2019, immediately they were being released, since there was no case against them. Because reference was, order is at page 23, lordship. matter whether when a reference is being made before the foreigner strike.
no case.
When there is no reference, a
Yes,
person
anyways,
cannot
I think this
outlive,
is a
cannot
case.
be-
This is one case which will require in-depth hearing. Yes, why you are not filing affidavit?
But I'll file affidavit, my lord. I'll get instruction, but 2 weeks, my lord, I'll file affidavit.
fine.
Details. Sector.
Mr. Deeping, the learned counsel appearing on behalf of the
Respond number 2 and 3, my lord.
2 and 3.
4 may not be a party, should not make party, my lord, because
Whereas tribunal has also been made a party. On behalf of the respondent number 2 and 3 submits that he would like to file an affidavit. The matter, list the matter after the affidavit be filed. List the matter on 23rd of October 2024. Affidavit be filed on or before the next.
always.
Is yes, it's not hearing you.
Petitioner being legally or further filed petition before respondent number 5 for inclusion of their names in the parta. That was dropped on the plea of this reason of summons by the opposite party, your lordship. Inter alia directed to file petition before higher authority. File petition before respondent of court that was not accepted and directed to go and file appeal before respondent number 3. File appeal before the respondent number 3 that was not entered in till date, your lordship.
I'm for respondent number 6 and 7.
Mr. Chutia, what is this appeal being filed by whom? Who is deciding the appeal?
Under the against the order of my lord assistant revenue officer, assistant revenue, so they can file the appeal before the secretary revenue. My lord, as per my lord, by enacting the my lord Karbi Anglong Land Revenue Act 1953, we have adopted the Assam Land and Revenue Regulation. Only with modification that deputy commissioner is the revenue officer, and the commissioner is the executive member in charge, and the state government is the executive committee of the autonomous council. By way of that modification, my lord, we have enacted the my lord Karbi Anglong Land Revenue Act 1956, my lord. So the appellate authority, my lord, it is the order passed by the assistant settlement officer. They can prefer the appeal, my lord. He is the subordinate to the secretary revenue, my lord. Appeal can be filed before the secretary revenue. And in a mutation case also, my lord.
Appeal can be filed before?
Secretary revenue.
They have filed it.
Yes, your lordship.
It is a my lord, dispute is regarding the private dispute between the parties, my lord, regarding the hereditary right of the property.
But why you are not deciding that? Simple question is, whoever it is, decide it. Her only prayer is that.
My lord, the appeal is required to be decided, my lord.
It's all. That's the only prayer. There's nothing more than that.
My lord, my lord.
See the prayer.
My lord.
Shall not be directed either to entertain the appeal or dispose of the same by speaking at an early date and or to transfer to the respondent number 4.
Lordship, this was a bit like it.
The instant petition has been filed by the petitioner, being agreed by the inaction on the part of the respondent authorities in disposing of its appeal, which was filed,
There is no settlement official.
filed against before the secretary, Department of Revenue.
Settlement official.
No, it is before the secretary. They have corrected it. No? You filed it before the secretary.
Condonation petition, yes.
Filed before the respondent number 3, thereby challenging the order dated 15/3/2012 passed by the Assistant Settlement Officer Diffu Full stop. Taking into account that the said appeal was filed in the year 2022. 22. And of an impugned order of 2012. So this court directs the respondent number 3, who is the appellate authority over he's the appellate authority, na?
Secretary, I mean, appellate authority.
Who is the appellate authority against an order passed by the assistant settlement officer to dispose of the said appeal. Within a period of 45 days from the date of service of the instant order. Full stop. This court makes it very clear that this court had not dealt with the merits of the case, including the question of limitation, which would be open to the Secretary Revenue to decide in accordance with.
Nine.
Please, Your Lordships. My lords, in this matter, I am appearing for Ms. R.S. Chaudhary, Standing Counsel, some State Legal Services Authority. Due to some urgent work, she has to move out of this court. Later, the matter may be taken up some other day.
You want some time. The request of the learned counsel for the respondent matter stands adjourned to be listed again on 9th of September 2024.
Much.
Mr. Akhan, there are many orders passed by me. Find out this time. On these aspects, this matter.
Lordship, I have one of my matter also. Lordship.
Yes, what is this?
This is the council for this was to offense.
From cancelling the allotment of land measuring so and so, removal of their name so many. Why should this court entertain all these type of matters?
My lord, actually, my lord, I am the owner of this land, my lord. This land was allotted to me. I paid the premium, my lord. Now they want to widen the national highway, my lord. They have marked my land, but they have not issued any notice to me, my lord. When I submitted the representation, they said that I am in process. So my house I'll be thrown out.
Have been thrown out.
But because of this, stay order is offered.
No, how can there be an interim order for that?
My lord, without
Your only question is you will be entitled to compensation.
if
nothing.
they acquired my land.
If they acquire your land, they will be entitled to compensation. Patta land, you have not been granted a patta.
No, Lord, it's allotment only.
It's only an allotment. So they can, obviously you have a right. There's no quarrel. You are a person interested. You will be entitled to the compensation. It is not that they will, you would not be. Who is making the road?
Road is by the PWD Lordship.
Okay.
But
PWD
this was
will
by
have to
the
pay it to you
civil
to
authority.
acquire the land from you. It is a different thing. They have not issued the patta. It's a different thing. Where is that allotment?
It is not-
Hmm?
Lordship, I kindly say at least at page 26,
20?
starting from 26. And his name is at page 20. 31. 31.
Page?
31.
Serial number 62. Oh, sorry, not 62.
Dharnikanta Iman,
Sorry.
2 katha 10 lectures. When was it given?
It was originally in the name of their father, Lordship. Subsequently, the allotment was in the name of the two sons, Lordship.
So you accept this?
At least on fact, this is the fact, Lordship.
No, you have no instructions. So I think
Instructions,
they,
some instruction I
they have
received.
to get that instruction.
In fact, I was directed.
This is BTC. Gosaigaon, BTC. You are also BTC.
Yes.
You are also PWD.
Just for BTC.
Huh?
EWD has no road lordship.
No, who is trying to evict them?
The district authority, I mean civil authority, Lord.
Civil authority for whom?
On behalf of EWD, Lord.
So there you are also there.
Payment I am going to make, Lord.
So under such circumstances, the question is, if that be so, because your notice is in respect to LA case number 1/2023. You are the requiring authority.
Lord.
So you being the BTC authority, when an allotment has been made, do you admit to this document at page 26? Because there is no signature, nothing. This signature, do you admit to this document?
One signature is there.
Page 31, there is a signature.
Huh? Who has signed this?
Lordship may also see the certified copy at page 19. English translation is at page 18.
What is this?
Page 18, it was in the name of the two petitioners, Lord.
Copy of the money.
Initially, it was in the name of the father.
Hmm.
Subsequently, in the name of the two sons.
So you have a right. No, if you don't deny to these documents, it's okay. You cannot. You will be, he's the person interested.
My submission, some instruction I received, Lordship, but these are not complete. In fact, these are just copies of the documents annexed in the petition. So Lordship may either dispose of this matter.
Now, 1 lakh is being given. Minal Kanti Das, 1 lakh.
That is the premium he has.
Premium.
Oh, he has got the premium. He has paid the premium.
Then, my lord, my name is there in the Jamabandi also.
Okay, when can you get it? See, there is a stay which is not going to help you out. The
Yes.
stay is going against the interest of the BTC because you want to construct the land. So we have to, this interim order, if it is continued, it will be against the public infrastructure.
Yes.
When do you want?
Lordship,
If you get a telephonic conversation from this aspect, we can finish it off.
even yesterday evening also I reminded them.
Hmm.
Lordship will take up this matter after 2 weeks, Lordship. In the meantime, I'll get some copy.
2 weeks, many times 2 weeks you have taken. Because the interim order is continuing. Every
Yes.
time, see, 7/8, 19/7, 23/8, 28/3, 21/2, 21/1, 24/5. See? Then we do one thing. List this matter again on 11th of September 2024. Full stop. Taking into account that there is an full stop. It is observed, no, a final opportunity is given to the BTC to obtain the complete instructions in the matter and if need be, to file an affidavit. If the stand of the petitioner is denied on factual aspects. Full stop. An attempt shall be made to dispose of the said petition on the next date. Interim order passed earlier shall continue.
Lordship has not mentioned any time.
13, 11th or 11th.
7th of Obliged, Lord.
Oh, this matter. Railways.
I filed an affidavit.
Matter should have been taken earlier, na? So now, from the affidavit, it is outside.
Actually, my lord, the statement made in the affidavit, it is not actually correct. Actually, the poles were erected 30 feet from the boundary of the land.
From?
But they have stated, my lord, only 2 meters from the boundary. They have erected the poles, but it is not the correct. statement.
How much it is?
It is 30 feet
From?
from boundary.
From your boundaries. So then,
So if it is done, my lord, then my lord, my entire plot will be
30 feet from the?
from the boundary of the wood. In fact, there is no boundary of the petition, in the land.
Where,
If
where, where?
lordship may kindly look into my lord, the photographs.
Where photograph? They have given this. 132 kV transmission line from Sankordev GSS to Lonka TSS.
The red color boundary wall is the different person's land lordship.
Huh?
Thereafter, the red color boundary wall, that is the land of another person. And thereafter lordship, that be
6
6 feet wide at a, there is a road, a village road lordship.
Where is
Then-
your road? Where is your house?
There, my lord, 2 tin shed houses there. my lord.
Ah. Then? Where do you want to stay?
Okay.
This is where?
They are erecting the poles, my lord.
Where?
30 meters from the boundary of the land.
Of your land?
Yes.
It's too far off.
Oh.
30 meters is pretty far off.
Concern is that, my lord, they have to erect the poles just after 2 meters of the boundary. But they have not done that.
Your submission earlier was that these poles are put in such a manner that it runs through your land,
Through middle of the land.
middle of the, is it so? No,
Yes, lordship. It is not like that, lordship, because lordship, yes, it is true that for erecting that electrification, lordship, that his land has to be acquired, and that acquiring process has been already almost over, lordship. Only the compensation amount has to be given, and the electrific that responding authority has done, lordship, that erection and that foundation has been constructed from the as per their affidavit and as per their instruction, lordship, that it has been constructed from the 2 meters from the village road, lordship. So
from the village?
Village road, there is a village road at the boundary of his road land. There is a village road, lordship, that I have annexed, lordship, and thereafter they have kept vacant only 2 meters land, and thereafter they have constructed that. It is there.
Who have constructed?
Yes, no, railway authority. Railway, I mean, railway means that
No, my
the construction.
simple question, does it run through his land?
Through his land, lordship.
It runs. Why you are going into all these things? His only contention is this land. Earlier, it was outside his land. Now it runs through his land. His contention is.
His contention is that, lordship, he is also willing to give the land, to hand over the land to the authority, but it should not, as per his statement, lordship, it should not be at the middle of his land, because if that pole is erected at the middle of his land, his both side land will be misused. There are some because the authority will give compensation to that plinth and that that portion between the 4 legs. That land and that compensation will be given. So if as per his contention is that, lordship, if he is getting it is constructed at the middle of his land, then both side land will be misused. And our contention is that we are not erecting it at the middle of his land. We are erecting it at the boundary of his land, and it is only 2 meters gap is there, lordship, for safety purpose from the village road, lordship.
Where is it?
This is, lordship. This is boundary wall, lordship.
Paragraph?
Paragraph, lordship.
4.
4, lordship.
There is a 6 foot wide village road at the one of the land with by the villagers in the. That is for 4 leg pylon.
Page number 36.
And you denied these contents of the affidavit. Then what to do?
My lord, then I will file a affidavit in this regard. my lord.
But that it is a very
Okay, file your affidavit. We'll have it on 20. The respondent has filed an affidavit taking into alien that the construction work has not been done at the middle of the petitioner's land as claimed. It is also mentioned that there is a 6 feet wide village road at the boundary of the petitioner's land, which is used by the villagers, and the construction work has been done, bracket, that is for 4-leg pylon, bracket close, keeping vacant a distance of only 2 meters from the said village road. And that too for safety purpose, which is essential as the said tower will be used for electrification. The counsel appearing on behalf of the petitioner, however, states that the said statement is incorrect, for which he would like to file an affidavit. List the matter, taking into account that there is an interim order passed by this court. List this matter again on 29th of August 2024 at 2 p.m.
As,
Interim order passed earlier shall continue.
as on that, Lordship, there is already one post has been erected and another construction is going on, Lordship. And so, Lordship, as it is connecting, relating to the operation of the train electrification of train, Lordship. So, Lordship.
That is why I'm fixing it such an early date. I'm fixing it on 29th because he has to file his affidavit on 27th or 28th. Take it up.
Actually, one report from the circle officer is also maybe called for, Lordship, because Lordship, he will say exactly, Lordship, because they are the official person and they will go to the spot and they will give the actual measurement, Lordship. That is required, Lordship, because otherwise he will say, I am not, I have constructed there. I will say I have not constructed there. Again, it will be. So,
Miss S. Bolu appearing on behalf of the circle officer.
Hosai.
Hosai. They'll also obtain a instruction as to where the whether the line. So no, not possible. With such a short span of time, asking them it is impossible. How will they do? Tell me.
They will send one Latmander and he will get the details, Lordship, because they will measure it.
Ms. Esbulwa, the learned counsel, appearing on behalf of the circle officer Hosai, shall also obtain necessary instruction. Lanka Revenue Circle also shall obtain necessary instruction as to whether the electrification is carried out through the middle of the petitioner's road.
14.
Interim order passed earlier shall continue.
In this case, Lordship, the petitioners have preferred a statutory appeal under section 53A2 of the Assam Land and Revenue Regulation, Lordship. That statutory appeal was filed in the year 2021 and it was not yet been disposed of. That was the allegation made by him. Accordingly, your Lordship has directed me to obtain the instructions why it was not yet been disposed of. He has given a file number, Lordship, but that file number was wrongly given by him. And today he has filed an IA, right? But even then, Lordship, in that case, in the file number, we are unable to find it out. And your Lordship has expressed your Lordship's mind on that day. If it cannot be found out, in that case, they will file fresh one and it will be disposed of within a time frame. That was the, so Lordship, but there, that file number was wrongly given to us. Because of that, we are unable to find the files. Now the new file numbers he has filed an IA, the file numbers he has put in that IA. So may I suggest, Lordship, that let it be found out by the department. If it is, it can be found out well, and otherwise they will file a.
We'll have it on 28. You have the file number now. Just get your instruction whether the file is there. Otherwise we dispose it off.
Lordship.
And thereby directing them to file the appeal. Only thing is why I'm saying is if they have not filed it and they are filing it here for the first time, unless there is a file number. Why it has not been registered? So just find out that and then let me know. Because there is a question of limitation also, na?
Regarding the file number. May I place the letter regarding the file number?
Yes.
I do not know, Lordship, it's a statutory appeal. It is to be before the district commissioner, but the additional district commissioner has sent all the files to the circle officer. The letter from that, just now I have seen.
How can he do so?
It will long number. File number কোনটো? এবার একটু কারেক্ট দেখে এইটো না?
So this
Page
is number
number
is
8.
what?
Page number 8, Lordship. They type
ERKG 43 oblique 2020-307.
18 into 20, it should be, I think, 2021.
Huh?
No, Lordship, as
2020.
because it's filed in the year 2021, most probably it should have been 2021, but the original copy is not at all legible, Lordship. Oh, it is to compare, na?
Anyways,
But even then, Lordship, we will try to find it out.
Mr. H. Sharma, the learned counsel appearing on behalf of the district administration submitted that based upon the file number as was provided by the petitioner, which was reflected in the order dated 16/8/2024, the statutory appeals date to have been filed by the petitioner could be located. However, in the additional affidavit filed today, there is a mention of another file number, that is BRKG-43/2020/307. And in that regard, he would like to obtain
It is work at
necessary instructions. It was to list the matter on 31st of August. 31st, huh?
Your Lordship has fixed it on 28.
31st. Yes, what is this? It is okay, order name. It is.
Plus, Lordship, my lord, I am very surprised, Lordship, for the sole respondent. And my lord, that I have received the instruction, as per the instruction, my lord, the deputy commissioner, they did not send the proposal, my lord, that's why we could not, my lord, sanction the amount. In the writ petition, deputy commissioner is the party. And here in a contempt petition, they did not make the party, the concerned deputy commissioner. So that's why they are sitting, Lordship, they are not sending the, my lord, the proposal.
Mr. J. Hendick, the learned counsel appearing on behalf of the respondent, contender, respondent submits that the revenue department cannot proceed with the finalization of the verification without the deputy commissioner, district commissioner of the district, concerned district, initiating the proposal. Full stop. Full stop. However, this court finds no affidavit being filed along with any documents to show that the respondent have duly intimated, asked the deputy commissioner for sending the necessary papers for due compliance to the order passed by this court on 28/7/2023 in WPC number 2239/2023. Full stop. Mr. J.C. Hendick, the learned counsel, submits that he would advise his client to do the needful. List the matter. Advise the respondent to do the needful. List the matter again on 30th of September 2024. 30. for an update. You just move the deputy commissioner. Why you are not moving the deputy commissioner?
Already been sent, my lord. We send a
That
letter to
way,
the deputy commissioner.
No,
They
if
have
the deputy commissioner is not doing, then something has to be done. If the revenue department has
My lord,
no
they
authority of the deputy commissioner, God forbid the deputy.
we send it, my lord, on my lord, that 5/4/2024.
The-
This is the letter.
See, as per settlement rule 1, the deputy commissioner is bound to listen what the state government says. And then you don't say that this commissioner and secretary of the AR, he asked him and he's not doing it.
We already been sent, my lord, that's why.
I'm sorry.
Oh, it 31, no? 39.
একেলগে দুখিনি কথা দিছে।
Hello? দেখতে যাচ্ছ তো? তেনেকে মাতাটো হৈছে।
16 তাৰিখে, 16 আঠৰ। 13 18 কোনখন বাৰু হেৰি?
এখন 7 তাৰিখে পঠাই।
7 তাৰিখে আহিব।
এইটো ভুল কৈছে আকৌ। গম পাইছানে?
এইখনে পাই পেলাই পঠাই দিম।